Biribonwaho, the Solicitor General of the Republic of Uganda, Her Excellency Anna Reisman, the Country Representative of Uganda and South Sudan for the Konrad Adenauer Stiftung, Her Excellency Dr. Kaja Kashbauma, the Head of Austrian Embassy and Development Cooperation, Her Excellency, the representative of the Ambassador of Germany, Ms. Sabine Johanna, the Executive Director of Fidelis Leadership Institute, Fiona Wall, the distinguished representatives from the Justice, Law and Order Sector Steering Committee, Mr. Asimwe Anthony, the Vice President of the Uganda Law Society, and distinguished guests, you're all welcome to today's launch of the very first ever public interest litigation compendium in Uganda. It's going to be the first of its kind, and we are honored that on the eve of the birthday, we call it, of the Constitution of Uganda, we get to celebrate such a publication, and such a publication gets to be launched. So I'd like to take this honor to welcome each one of us. I hope we have all had breakfast, we are feeling good, and we are having a good morning. So ladies and gentlemen, my name is Amanya Belinda, and I'm going to be taking us through today's program. So ladies and gentlemen, without further ado, I'm going to take this honor to welcome the Executive Director of Fidelis Leadership Institute, Ms. Fiona Wall, to welcome us to today's event. Ms. Fiona Wall, you're welcome.
The Honorable Justice Richard Butera, the Honorable former Deputy Chief Justice, our Honorable Pius Perry Biribonwaha, the Solicitor General of the Republic of Uganda, Her Excellency Anna Reisman, the Country Director, Konrad Adenauer Stiftung, Ms. Sabine Schmier, here on behalf of the German ambassador, Dr. Honoria from CEPIL. We have some distinguished academic experts here. Dr. Kabumba from Makerere University, Alexandra Han from CAS, Dr. Hassan Sher from Defend Defenders, Ms. Nur Nachibuka, the Deputy Executive of SEHARD, members of our panels, our distinguished guests from the Attorney General's Office. We have distinguished guests from the media here, the Fourth Estate. Ladies and gentlemen, you're all very welcome to this momentous occasion. Please give yourselves a big hand clap for being early. Our chief guest, it's with profound honor and gratitude that I stand before you today on behalf of the Fidelis Leadership Institute at this momentous occasion, which is the launch of the first public interest litigation compendium and case decisions in Uganda from the time of the promulgation of the 1995 Constitution to date. My lord and guests, this compendium is very unique because it has been designed not only for the legal profession, like we usually have compendiums of this nature designed, it has been designed for the ordinary Ugandan. The 1995 Constitution ushered in a new legal order. It was deliberate in its commitment to fundamental rights and freedoms, accountability, and access to justice. It changed the legal landscape forever by dismantling the restrictive common law principle of locus standi, which means you should actually be directly affected in order to come to court, which had limited access to courts to only those who could prove personal harm. My Lord and guests, Article 51 and 50, subsection 2, and 137(3) of the Constitution of Uganda empower individuals and organizations, using the word anybody, to seek court redress for rights violations or unconstitutional acts, opening justice to all Ugandans and all citizens, and turning the law into a tool of protection of the vulnerable. My Lord and guests, we want to thank our partners from Konrad Adenauer Stiftung, because as the Fidelis Leadership Institute, our mandate is to create a critical mass of ethical leaders for Africa. We believe that Africa's solutions will be best provided by African minds using African-grown innovative ideas. And we believe that ethics is the question that would set us apart and set us on the path that other countries have trod. As we speak right now, we are on the continent that is literally the last course for survival. It is the cradle of humankind, and many believe that it will be the last, should I say, the last bit of earth that will be left for survival. And as we speak, we still are very rich in minerals, in a young population. We are still very resourced, but yet we see this country, this continent riddled with poverty, riddled with everything that seems to be wrong with this world. The difference is not that we lack. The difference is that we have not had leaders for a long time, or a culture for a long time that believes in doing what we say, that believes in sacrificing for the greater good. My Lord, the Fidelis Leadership Institute is a group of very young people, I'm the eldest, that believe very vehemently that we can actually transform Africa if our leaders are ethical, if they are faithful to their mandate, their purpose, if they are available to the poorest and the neediest of their communities, and if they are teachable in their reputation. I want to thank the Konrad Adenauer Stiftung because they are passionate about everything to do with good governance. And when they heard that we wanted to do something like this, we went to them and proposed this. I want to give a big hand clap to Anna because she just embraced it and said, when do we do this? The constitutional innovation that we are talking about marked the birth of public interest litigation in Uganda. It's a legal tool that has since enabled individuals and civil society to champion the causes of those unable to speak for themselves and to hold the state accountable to its constitutional promises. My Lord, the legal profession has for a long time, the legal profession in Uganda, over 60 years, provided legal aid and pro bono services and done public interest litigation. But these sections, these articles of the Constitution actually give this access of the Constitutional Court to every Ugandan. And that is why we are here today, and we're calling it the first compendium, because thanks to CAS, once again, this compendium is going to be translated into various languages because we want the last person in the last frontier to understand what the precedents, the cases that we have picked speak about. We want this compendium to arm every Ugandan who goes to a court of law for public interest litigation to have the precedents to persuade court in their cause. Over the last 3 decades, public interest litigation has been very instrumental in shaping our democracy. Courts have, through these cases, declared 18 statutory provisions unconstitutional. My Lord, we picked only 24 cases in the last 30 years that we thought were very impactful on the constitutional history of the country. So, under these cases, courts have, through these cases, declared 18 statutory provisions unconstitutional, prompted 6 major legislative reforms, reinforced the principles of separation of powers that are fundamental to good governance, and these victories are not abstract. These victories translate into greater protection of freedoms, equality, and dignity for ordinary Ugandans. We're speaking a lot about ordinary Ugandans, my Lord, just to let you know, our guests, that we are live on LinkedIn and YouTube, and we ask everybody out there to spread this message, share the link, because we want everybody to access information because knowledge is power. This compendium we launched today captures this journey. It is a carefully curated resource of landmark decisions, decisions that have defined the contours of constitutional rights, advanced gender equality with almost 100% success in those cases. And what we mean is they were won. It has strengthened fundamental freedoms and expanded access to justice across multiple spheres of public life. It's more than a record of cases. It is a tool for education, accountability, and empowerment. Today we shall discuss how effective we are as a people in implementing these things. As we prepare to commemorate 3 decades of the 1995 Constitution, we should give ourselves a big hand clap, because that is tomorrow, the birthday of our Constitution. Can we give it a big hand clap? We are reminded that a constitution is only as alive as the commitment of those who uphold it. The courts have done their part, but it's also the duty of every citizen, every advocate, and every leader to ensure that the Constitution's promises are not left in the pages of law books, but are realized in the lives of our people. To our distinguished guests today, I urge you to see this compendium not as an end, but as an invitation to continue building a culture of constitutionalism, civic education, and strategic litigation in the public interest. Allow me to conclude with the words that resonate with the spirit of the gathering. A constitution is not merely a document. It is it's the mirror of a nation's soul. They're not my words, but they're fantastic words. May this compendium reflect our nation's unwavering commitment. Allow me, my Lord, to thank Konrad Adenauer Stiftung that have been our partners in this, the editorial team that's made up of CAS and FLI staff. We want to thank the people that have given us commentaries and forwards, starting with His Excellency, the German Ambassador, His Excellency Matthias Schauer, Her Excellency Katja, I'll not murder her second name, yes, from the Austrian Development Agency, and many, many more. We have partners here, people that have been leaders in public interest litigation. Mr. Hassan Shire represents an organization that defends defenders. Can we give them a big hand clap? Dr. Kavumba Masiko is a renowned, should I say, activist for human rights in this country, and he has raised a lot of activists. Dr. Honoria, whom I owe my constitutional education, has, I think, as long as the Constitution has been here, been teaching law. Let's give them a big hand clap, these historical contributors. But my Lord, I would like everybody here. First of all, I want to recognize our Solicitor General. He has been practicing constitutional law in Parliament for nigh on 20 years before he became the Solicitor General. But my Lord, I would like everybody here to recognize the fundamental role you played as the head of the Constitutional Court for almost 10 of the years that we're talking about. Can we give him a big hand clap? I appreciate every lawyer, every judicial officer, every research assistant, everybody that has contributed to the cases that are reflected here. But I also want to recognize the victims that had to suffer for us to have these fantastic examples and precedents. So thank you very much. I know I talk a lot, but that is the crime of every lawyer. But I want to welcome everybody online. This will be a short meeting. We are going to launch this compendium. And my Lord, this compendium will be available on the websites of the Konrad Adenauer Stiftung. And on your tables, there is a little card that has, we've gone digital. So it will be digital. We are increasing digital access to legal resources. And we are also going to have these resources available once they are translated. Thank you very much and have a great morning.
Thank you very much, Fiona. Another round of applause for the great lady that heads the team at Fidelis Leadership Institute. She's done a great job to lead a mass of critical, ethical leaders in this generation and in this nation. Thank you very much, Madame Fiona, for that speech. Next, I'm going to be welcoming Madame Anna Reisman from Konrad Adenauer Stiftung, the country representative of Konrad Adenauer Stiftung, Uganda and South Sudan, to come and give us opening remarks from CAS. Thank you very much. You're welcome, Madame.
Honorable Justice Richard Butera, the Honorable former Deputy Chief Justice, Honorable Pius Perry Birimboa, the Solicitor General of the Republic of Uganda, Excellencies, ladies and gentlemen, please allow me to stand on the protocol established by the former speaker. Fiona Wall, welcome to all of you. We are very grateful to have all of you here this morning. It is a very special moment for me to stand here today together with the Fidelis Leadership Institute and to launch the first compendium of public interest litigation cases in Uganda. And the occasion could not be better, but the 30 years of promulgation of the Ugandan Constitution. And today for me is not the right moment to speak a lot, so I will be very brief and rather listen and learn. And it is a privilege to be in this room with all of you to learn from you. But allow me briefly to explain why the Konrad Adenauer Stiftung, being a German political foundation, why we have partnered with the Fidelis Leadership Institute to publish this compendium. When Fiona Wall, the leader of this incredible institution, first approached me with the idea of a compilation of public interest litigation cases in Uganda since 1995, I indeed didn't hesitate a second and agreed in supporting this idea for several reasons, but today I will speak only to 3 of them and allow me to mention them. Our mission is shaping democracy together, so my reasons will be along these lines. First, public interest litigation is a result of the 1995 Constitution that provides that any person or organization may bring an action against the violation of another person's or group's human rights, and that allows any person to petition the Constitutional Court for the interpretation of the Constitution, which meant indeed a major paradigm that came with the 1995 Constitution. Thus, the study of the public interest litigation cases is also a study of the shaping of the constitutional practice and reality, as opposed to the constitutional theory and ideals. This is the shaping. Secondly, public interest litigation is a deeply democratic instrument meant to serve in the interest of public and in protection of human rights, constitutional freedoms, and social justice. It is therefore highly revealing to learn whether or not the presented cases in the compendium and the actions following the court decisions help to advance democracy in Uganda, and if so, how? In his foreword, His Excellency Matthias Schauer, the ambassador of Germany, addresses these aspects as well. And allow me to quote him. First of all, he talks to the public interest litigation as an instrument that is not known to the German Constitution. He also mentions that about 1/3 of the cases that are featured in this compendium would not have been accepted by German courts. He goes on and asks, so what makes an interest public? Who defines that? By what criteria? If Parliament, for example, as hundreds of elected representatives of the people, has not seen a need to pass a law to regulate a certain topic, is the claim that regulation is lacking automatically in the public interest? I will leave it at here, and I'm happy to learn from you. And the third reason why the Konrad Adenauer Foundation immediately supported this idea is because the compendium does not only represent a retrospective. It is much more a reflection of how these cases have contributed to what Uganda is today in legal, political, but also social terms. And it does not only capture the past and the present. We believe that it is also a highly future-oriented source that will allow a variety of actors, and not only legal practitioners, to learn how to integrate litigation with complementary advocacy tools, such as media engagement, community mobilization, and policy dialogue. Creating opportunities for dialogue and civic education, they are at the core of our work at the Konrad Adenauer Stiftung. And I have this book, and when I read the Chief Justice's Odoke book, The Search for a National Consensus, on the making of the Constitution, I believe that dialogue and civic education were also the ideas and the ideals, yes, the foundation on which the new Constitution emerged. As much as the book is a great piece of accountability for a democratic process, for a very unique process in making a constitution, I find chapter 8, Consensus Towards a Social Contract, especially insightful. In this chapter, Chief Justice Odoke first speaks of a consensus, what it is and what it is not. And he talks of the importance and the impact of consensus. And I may quote, "Consensus was stimulated through public debate and concretized through the submission of views and the debate in the Constituent Assembly. Consensus was clearly a product of dialogue, tolerance of diverse views, the spirit of give and take, compromise, and respect for the views of the minority. In the process, these democratic values were inculcated into the minds and hearts of the people. These values are important for the promotion and sustainability of democracy and constitutionalism in Uganda." And he goes on, "These principles are very important because, unlike technical details, they do not easily change. They can stand the test of time." And so here we are, 30 years later, with some test of time, making our contribution to the promotion of democracy. And I would like to conclude by once again quoting Chief Justice Benjamin Odoke. And this is also the last page of his book. "The people of Uganda recognize that democracy is a journey and not a destination. And I believe all of us here today and everywhere, we see indeed the decline of democracy in many, many places worldwide. In Germany, we are also challenged by decline of democracy through several actors. from the extreme right and extreme left. So I continue the quote. Ugandans cannot achieve in 30 years, and 30 years are today, and the book was written in 2005. Ugandans cannot achieve in 30 years or so the same level of democracy and constitutionalism which has taken the Americans 300 years to achieve. But Ugandans have made a firm commitment to embark on the journey to democracy and constitutionalism. This journey is not an irreversible process. Significant achievements have been made, and Uganda may perhaps be beyond the faltering first steps. Nevertheless, challenges remain in the way, namely, winning the political process from military influence and violence, ensuring peaceful, orderly, and predictable political succession, eradicating corruption from political processes, and building viable and democratic institutions. I think these debates are still very much in place today. And if I may continue, civil society and the entire population must be empowered through public awareness, programs to promote civic competence, and create informed public opinion. And I believe that this compendium is a contribution to this. Thank you very much.
Thank you, Madam Anna, for that great speech. Allow me to request you to give her another round of applause for that great speech. I must say it is a unique day that we get to see two great women standing before us and leading one of the biggest celebrations of the day and memorable celebrations. Another round of applause to the great ladies in the house. As a lady, I am proud of the women. Thank you very much. And as said by Madame Fiona and Madame Anna, one specific thing we look at today is that today we gather here not only to unveil just a publication, but to celebrate 3 decades of civic courage, legal innovation, and the power of public interest litigation that shapes justice and accountability in our country, Uganda. So from the speeches that are being said and from all the commentaries and what you're going to be reading from the book, I would like to commend and request us to proceed with purpose, reflection, and hope to making Uganda better and shaping a better country for everyone else. Thank you once again. And you're welcome to everyone who has been joining us. Today we celebrate the very first compendium on public interest litigation in Uganda that has been authored by Fidelis Leadership Institute in partnership with CAS, which is Conrad Advenera Stiff Tank. So ladies and gentlemen, proceeding with our agenda of the day, we're going to be listening to an opening address from the Solicitor General, Mr. Pius Perry Biribonmoha. You're welcome, Mr. Pius.
Thank you very much for the introduction. Now, I was getting worried. They kept referring to me as honorable, honorable, honorable. But I think they got it right. I'm just simply Mr. Good morning. I'm here representing the Honorable Attorney General. Fiona explained that's why they kept referring to me as honorable, yet I'm not. He was unable to make it, but asked me to come and be present at this very important occasion, as everyone has said. The Honorable, the Deputy Chief Justice Emeritus, I will request also to stand on the protocol that was earlier very well established. Distinguished members of the bar, ladies and gentlemen, I'm profoundly honored to stand here before you and make these opening remarks at the official launch of the first public interest litigation compendium in Uganda. A special tribute goes out to the architects that perceived the idea to compile and publish a compendium on public interest litigation in Uganda. In my view, the compendium is not a mere collection of judgments, but a dynamic and transformative facet of our jurisprudence. It is a testimony of the evolving role of our courts in shaping the rule of law, good governance, deepening our democratic system, but most importantly, protecting the inherent fundamental rights of our people. The compendium stands as a reminder that the Constitution of Uganda is not a static document, but a dynamic charter that lives through interpretation, enforcement, and the vigilance of both state and non-state actors. From our vantage point at the Attorney General's office, public interest litigation represents a fundamental shift in the traditional paradigm of litigation. It moves the focus from a private dispute between two parties to a broader quest for justice that resonates across society. It is a mechanism through which citizens and organizations can knock on the doors of courts and speak for the voiceless and demand accountability for the many. Therefore, public interest litigation has evolved into a vital tool for ensuring that justice is not confined to the privileged few, but is accessible to all, especially the marginalized, the vulnerable, and those without the means to directly access the courts. The compendium that will be officially launched today, the political questions. I therefore sincerely extend my appreciation to the judiciary, the legal fraternity, our development partners, and civil society organizations for the collaboration and commitment that has made this publication a possibility. It is indicative that justice is not the work of a single institution, but a shared responsibility. As far as the Attorney General's chambers is concerned, although our office has been on the opposite side of these cases, oftentimes, we reaffirm government's unwavering commitment to uphold the rule of law and defend, especially, the independence of the judiciary. The existence and flourishing of public interest litigation in Uganda is a reflection of our nation's democratic maturity and our collective belief that justice must be both a shield and sword for the protection of rights and for the advancement of the common good. Today, as we launch this compendium, I invite the public, the general public, lawyers, and non-lawyers alike, to see in this compendium not only past struggles and victories, but also a call to continue building a society governed by justice, fairness, and equality before the law. Let this publication inspire a new generation of advocates, judges, policymakers, and citizens who believe that the law is not an instrument of oppression, but a guarantor of freedom. Distinguished ladies and gentlemen, today we are not simply launching a book, we are reaffirming a commitment that Uganda shall remain a country where justice is accessible to all, where rights are respected, and where the Constitution reigns supreme. I say all this for God and my country. Thank you very much.
By now, you definitely know that I'm going to request us to give another round of applause to Mr. Pius. Ladies and gentlemen, allow me recognize Dr. Kaja Kashbaumer, the head of the Australian Embassy, who has just, the head of the Austrian Embassy, who has just joined us. You're welcome. Thank you very much. At this juncture, ladies and gentlemen, I'd request us that as we reflect on the future and present and legacy of public interest litigation in Uganda, we are privileged and honored to receive a keynote address from a distinguished jurist who has served our nation with integrity, wisdom, and deep commitment to rule of law. Ladies and gentlemen, please join me in warmly welcoming Honorable Justice Richard Butera to deliver the keynote address of today.
Friends, allow me to adopt the protocol. It saves time and helps on mistakes, reducing them at least. I'm profoundly honored, and I want to take this opportunity to thank the Executive Director, Fidelis Leadership Institute, and the Country Director, Conrad Adenoir Stephen, for inviting me to deliver a keynote address at the launch of the compendium on public interest litigation, case decisions in Uganda, 1996 to the present. Literature on public interest litigation is not easily available in our country. The compendium we are launching today, therefore, is a great addition to our available literature. This is sufficient reason for me to start by congratulating Ms. Fiona Nabasa Wall, the Executive Director, and her team for the hard work, the planning, and organization you have gone through to produce this useful resource for us all to benefit from. The compendium has provided a collection of well-selected cases on public interest litigation decided by our Constitutional Court and the Supreme Court for the stated period. When advocates file cases in court, they do it on a case-by-case basis. Each case is decided, and one party is victorious, another is disappointed. For public interest litigation cases, however, as we shall see later in this presentation, there are no losers and there are no winners. Society benefits. After the conclusion of each case, the advocates and the judges proceed to handle other pending cases. We often do not spare the time to go back and look at the overall picture. What is the impact of the decisions we have made in our courts over time? This compendium is a product of a study of PRE cases over time, and it provides us with the wider picture. It provides us with answers to the following questions. What are the wider considerations, and what are the trends over time for which the selected categories of cases that our courts have handled, what do they indicate? What have we achieved over time when we have applied public interest litigation? The compendium is not simply a collection of 24 cases on public interest litigation that have been decided by the Constitutional Court and the Supreme Court. I've read the cases. It is clear to me that the team studied, they just did not read, many PLO cases and went through a time of careful and purposeful selection. The team had a selection methodology that they explain in the compendium. The selected cases were classified into the following categories: constitutional rights and freedoms, military justice and civil rights, criminal justice and due process, electoral and democratic governance, gender equality and anti-discrimination, administrative law and accountability. The team then went and pointed out success rates in the Court of Appeal and the Supreme Court for each category. And then they assessed the overall success and put it as 75%. The team proceeded to point out major constitutional developments after analysis of the selected cases. The team then went ahead to provide a guide on how the compendium should be used. From this guide, we find out who are the expected users of this compendium. They are the legal practitioners, students, academicians, civil society, policymakers, and the public. These compose the user group of what we have before us. The team provides us with a literature review that they undertook on public interest litigation. They provide a historical context and conceptual foundations for public interest litigation. They reviewed the works of Robert Okot, Loko Nyango, and Basil Christopher, to mention but a few, who I'm sure are familiar to people in this audience. The team analyzed the judicial perceptions of public interest litigation in Uganda and the contribution of civil society in the development and training of practitioners. They called for further training of lawyers in PIL techniques and constitutional interpretation. The team then proceeded with an analysis of each of the selected cases. I shall make comments on a few of the cases in the compendium simply to provoke debate at this launch. Public interest litigation is described by Justice Rugachingila of the High Court of of Tanzania, in the case of Reverend Mutakila versus the Attorney General of Tanzania, as the legal actions brought to protect or enforce rights enjoyed by members of the public or large parts of it. The judge described it as litigation instituted for the benefit of the public, who may be aware of their rights but lack financial ability to enforce those rights, as well as those who may have been aware, who may not even be aware that their rights are being infringed. When we discuss public interest litigation, we have to distinguish it from private litigation, where the individual's rights are at the center of the litigation. It's an individual's rights then that are being pursued in private litigation. In public interest litigation, it may be that the case is sparked off by an action of a private individual in the pursuit of his private rights, but the result eventually helps and leads to the protection of rights of many in the society. For this, I picked on the example of case number 20, which is in the compendium, which is the Supreme Court Constitutional Appeal number 1 of 1998, the Attorney General versus Salvatore Abuki. I picked on this because of its specific nature. It could not have arisen from any of us here. The respondent in this case had been tried and convicted for practicing witchcraft by a magistrate's grade 2 in Aduku Court in Lira district then, which is now Kwania district. He pleaded guilty, was convicted and sentenced to 22 months imprisonment, and in addition was banished from his home for 10 years after serving the sentence of imprisonment. The petition was filed in the Constitutional Court to challenge the constitutionality of the provisions of the Witchcraft Act, challenge the convictions and sentence by exclusion orders from his home. The Constitutional Court found that Section 3, subsection 3 of the Witchcraft Act was unconstitutional. It found that the exclusion orders were unconstitutional. The Attorney General appealed to the Supreme Court. The Supreme Court upheld the decision of the Court of Appeal and struck down Section 7 of the Witchcraft Act, that it was inconsistent with Articles 24 and 44A of the Constitution. This case was a great victory for the public generally. It was not a victory for Salval Abuki personally, because he was not even released from prison immediately. He was, for different reasons, ordered to serve his sentence of imprisonment, but was not to suffer the exclusion order. And here I want to quote some of what the judges said to illustrate what was driving the court. Justice Sekoko had this to say: "I'm convinced that it is cruel to ban a man from his own home because of alleged practice of witchcraft. It is inhuman to ban a man from his own land where he grows food. It is degrading to ban a man from his home because a homeless person has no dignity in him. Moreover, I think that the perceptions about the practice of witchcraft cannot be the same now as they were in 1958. Same was said by Justice Mlenga and Justice Odero. The Court of Appeal and Supreme Court availed themselves the opportunity not only to strike down the law, but explain what it meant to the people in the community, protecting their rights and not paying attention only to the petitioner. Now, Salval Abuki, the petitioner, was a peasant from Maduku in Kwanya. His fate would have ended up with him serving his sentence and the role remaining the same and staying on our statute book. What helped this peasant was that the advocate, Mr. Emoru, took up the challenge. He did that in pursuit of justice for the rural poor, who are illiterate and not have fought for their own rights. This case and others that we shall look at later bring out the important role of advocates in public interest litigation. It's an example of what our roles are. Another case in the compendium is Supreme Court Constitutional Appeal number 2 of 2000 and of 22, Charles Onyango Bo and Andrew Mwenda, and the Attorney General. The two petitioners successfully challenged the constitutionality of Article 50 of the Penal Code Act. Another case is Kalamaji and Robert Shaka versus the Attorney General, Constitutional Court Appeal petition number 5 of 2016. In the two of these, the petitioners successfully challenged Section 25 of the Computer Misuse Act for being unconstitutional. A similar case is number 3 of the compendium, which is Andrew Mwenda and another versus the Attorney General, where the petitioner was challenging the offense of sedition under Section 39 and 40 of the Penal Code Act for contravening the Constitution. All the three petitioners were on freedom of expression. We shall look at case number 1 as the example of how the courts handled these petitions on protection of rights of freedom of expression. The petitioners believed that their prosecution was a violation of their civil rights under the law. Eventually, the Supreme Court allowed their petitions, and it was a great victory, not for themselves, but for freedom of expression and freedom of the press. Freedom of the press is not freedom for journalists alone. It entails the journalists' freedom to investigate matters and publish their findings freely. But the main beneficiaries for this freedom are members of the public who read the published information, and they benefit from that freedom that has been the benefit of journalists. The freedom allows the public to receive information and be able to participate in the debate of how they are governed. I'll quote the words of Justice Mlenga extensively in this matter to drive the point home as to who the actual beneficiaries of this freedom are. The judge said, protection of the fundamental human rights, therefore, is a primary objective of every democratic society, and as such, is an essential characteristic of democracy. In particular, protection of the right of freedom of expression is of great significance to democracy. It is the bedrock of democratic governance. Meaningful participation of the governed in their governance, which is the hallmark of democracy, is only assured through optimal exercise of freedom of expression. He continued, Uganda, like any other democratic society, is committed to upholding the right of freedom of expression. That commitment, and indeed our adherence to democratic practices, may not be as long-standing as the older democracies, but it is real, and it is for that reason that it is entrenched in the most binding instrument of the land. The Constitution guarantees to everyone in Uganda the freedom to hold opinions and to receive and impact ideas and information without interference. I should add that the commitment is not evident in the constitutional provisions only. The enactment of 1995 of the Press and Journalist Statute to ensure press freedom is additional evidence of that commitment. In my view, it is because of that commitment and the importance of freedom of expression to democracy that restriction on the exercise of freedom is permitted only in special circumstances. Clearly, the judges concerned were on the freedom of expression for all citizens rather than the two journalists and others alone. The case number 11 in the compendium, and that is the Attorney General versus Kabaziguruka, Supreme Court Appeal number 2 of 2022, is also on that point. And the court's decisions, when you read all of them, their concern was not the petitioner alone. Their concern was the trial of civilians in the general court-martial. The court's decision was a victory, therefore, for all civilians generally and not the petitioners alone. Not the petitioner alone. I'll go to the main reason why the courts are going in to protect the rights and freedoms of citizens. And the Supreme Court stated that reason in case number 5 in the compendium, which is Zakel Orum and Reina Kafile versus the Attorney General. In that case, I'll quote what the court said. In Uganda, courts, and especially the Constitutional Court and this court, that is the Supreme Court, were established as the bastion in the defense of rights and freedoms of individuals and against oppressive and unjust laws and acts. Courts must remain constantly vigilant in upholding the provisions of the Constitution. It is the solemn duty of courts of Uganda to uphold and defend the Constitution. This is in the lead judgment by Justice Kanyehamba in that case. All the courts therefore carry this duty and have taken decisions and declared provisions of the Constitution unconstitutional. But then, to what effect does that take us? What is the impact of those decisions? What are the practical realities? I'll use the case of the Attorney General versus Susan Ichigura and 417 others to answer that question. In the Susan Ichigura case, 418 inmates on the death row successfully challenged the mandatory death sentence and the delays in its execution. The Supreme Court confirmed the Court of Appeal decision inter alia that the death penalty is now optional. We came up with the result that the death penalty is now optional, and it is within the discretion of the trial judge. I have a story to tell in my working life in this case. On the 29th of February, 1996, robbers stopped a Barclays Bank bullion carrying money from Entebbe to Kampala. They murdered a policeman that was escorting the money. They stole US dollars 240,000. The driver managed to escape and he survived. The two of the robbers were arrested in Kampala. One of them, Johnson Kamyawavamuno, a businessman, escaped. He ran through Matadi port in Zaire, now Congo, to Germany, and later came to UK. I was then Director of Public Prosecutions. Our efforts for his extradition to Uganda for trial were unsuccessful because we had a mandatory death sentence on our statute books. At around the same time, Itongwa started a rebellion against the government. His group committed numerous atrocities. The rebellion failed. Itongwa escaped. He ran to Denmark in exile. One of the victims of his murderous activities was Karachire, the regional police commander then in Masaka. He was kidnapped on Masaka Road at the junction to Kampiringisa. Our efforts to extradite Itongwa and Wavamuno failed because the European Union states do not allow extradition to countries where accused persons may suffer a death sentence. We had an annual conference of the International Association of Prosecutors in London shortly after the failed extradition proceedings. I presented a paper on the protection and promotion of human rights by prosecutors at that conference. I raised the issue of rigidity and unfair considerations in the protection of human rights, which end up protecting criminals or suspects of crime from answering for their crimes, and they deny victims of offense the right to be heard in courts. I presented the facts of the two cases and explained that the two countries were denying the families of the Ugandan families who were victims of these murderers opportunity for the murderers to be tried and justice to be done. I said, if it was two Ugandan school leavers that were found looking for jobs in Denmark or Germany or UK, they would have been deported immediately. But these two criminal suspects were being shielded from trial for their known criminal offenses. The countries shielding them from trial knew the offenses these suspects had committed. The two suspects had been advised by their lawyers to accept that they had committed the heinous crimes in their statements when they were applying for refugee status, and then they would use that in objection to extradition on the ground of fear of a death penalty. The Danish ambassador, who was my friend because we are both members of the executive committee of the International Association of Prosecutors, approached me immediately after my presentation at a tea break. And he told me he had understood my point, but preferred that we discuss the matter. We discussed and agreed that Itongwa should be tried in Denmark. A team of investigators and prosecutors from Denmark and Uganda were put in place. They traced the evidence. The evidence was video recorded here in our High Court in Kampala, then by Justice Bamwine. The evidence was adduced in the High Court in Denmark. Itongwa was tried, convicted, and served a sentence in Denmark. For Wamuno, we had to rely on witchcraft. He was informed a witch doctor in Mombasa would kill his case. He flew to Mombasa, and the red pole note says alerted police in Kenya. We were informed. Mr. Opio, a police officer from here, went and found him in a shrine in Mombasa. He was eventually extradited to Uganda, went through the Kenya courts on extradition. He went through trial. The Supreme Court has confirmed the sentences and the convictions by the High Court, and he's now serving sentence. If the two offenses were committed today, after the Susan Chigura decision, the DPP of Uganda would get the extradition by signing a memorandum of understanding not to request for a death penalty on conviction, because the death penalty now is discretionary and not mandatory. The DPP of Uganda would not have to rely on witchcraft. Public interest litigation, as we have it in Uganda today, has been mainly relying on the premises of Articles 137 and Article 50 of the Constitution. It is important for practitioners to get the distinction between the two articles clearly, because this has caused problems and people lose their petitions only on the failure to distinguish the distinction. Let's start with case number 13 of the compendium to understand the point that the courts have been making. And this is General Tinyafuza versus the Attorney General, which was handled by the Court of Appeal and later the Supreme Court. And the judges then made the distinction. And I start with the Chief Justice Wambuzi's definition of the distinction between the two articles. Justice Wambuzi says, in my view, jurisdiction for the Court of Appeal, for the Constitutional Court, is limited under Article 137(1) of the Constitution to interpretation of the Constitution. Putting in a different way, no other jurisdiction apart from interpretation of the Constitution is given. In these circumstances, I would hold that unless the question before the Constitutional Court depends for its determination on the interpretation or construction of the provisions of the Constitution, the Constitutional Court has no jurisdiction. This position of the law has been adopted and further clarified by the Supreme Court in a later case, Constitutional Appeal number 4 of 2020, a judgment delivered on 18th of September this year. And here I'll quote, I therefore find it to be settled position of the law that for the Constitutional Court's interpretation jurisdiction to be invoked, not only should a petition demonstrate that the interpretation of the Constitution is required, the question or controversy that is before the court should solely or primarily depend on constitutional interpretation of the Constitution. The court has made it clear that the Constitutional Court is not a trial court of fact. It is a court of original jurisdiction only for interpretation of the Constitution. When adjudicating a petition for interpretation of the Constitution, the court is empowered only to interpret the Constitution and additionally to grant redress that it may find fit, but after interpretation of the Constitution. The petition, therefore, shall not be filed unless it is for interpretation under Article 137. Article 50 of the Constitution, on the other hand, gives court the power to enforce rights and freedoms. The article empowers any person who claims that a fundamental or other right or freedom guaranteed under the Constitution has to be infringed or threatened and is entitled to apply to court. Now, for cases, therefore, arising under Article 50 of the Constitution, it is the High Court that should be petitioned. I would want to put forward a few of the tools that the two courts, the Constitutional Court and the Supreme Court, have been using in to develop the protection tools for human rights and freedoms guaranteed by the Constitution. We shall start with the one under the Tinyefuza judgment. And under this, they have developed a tool of interpretation of the Constitution that helps, and I'll quote it verbatim. Provisions relating to the fundamental rights and freedoms of the Constitution shall be given purposeful and generous interpretation in such a way as to secure maximum enjoyment of rights and freedoms. And when the state or any other person or authority seeks to do an act or pass any law which derogates on the enjoyment of fundamental rights and freedoms guaranteed under the Constitution, the burden is on that person or authority seeking a derogation to show that the act or the law is acceptable and within the derogations permitted by Article 43 of the Constitution. So, by this tool, constitutional interpretation has been adopted in favor of the petitioner, and that's a tool that the courts have relied on. Number two is that the courts have, in numerous cases, ensured and judged following the provisions of Article 120, sub-Article 2E of the Constitution, and that is that they apply substantive justice and do not follow and avoid undue regard technicalities. You'll see that in the case of Environmental Action Network versus the Attorney General and NEMA, which is miscellaneous application number 39 of 2001 by Justin Tabova. Following this, when you look at the cases by NEMA, they have generally gone for Article 50 of the Constitution rather than Article 137. And NEMA, in this area of environmental protection, a lot has been achieved by application of Article 50 rather than Article 137. Other tools that the courts have followed is guidance once the court comes to court, and the courts have developed tools to guide the lower courts. You see that in case number 14 of the compendium, which is Foundation for Human Rights Initiative versus the Attorney General, which is Constitutional Petition number 20 of 2006. And in this, the courts have provided guidance in the handling of election petitions. They have held that an accused person has a right to apply for bail under Article 23, Sub-Article 6A. They have held that courts have discretion to grant or not to grant bail. They have clarified the issue of mandatory bail where one has been on remand for 60 days for minor offenses and 180 days for capital offenses. They have also clarified and provided guidance that the High Court and Magistrates Courts, for the High Court and Magistrates Courts on how to bundle bail, and have stated that the bail is an important judicial instrument to ensure individual liberty. That the main reason for granting bail to an accused person is to ensure that he appears to stand trial without the necessity of being in custody. In the meantime, the court's guidance has helped the lower courts in handling bail, and okay, that's it on bail. Advocates have filed cases in the courts and they get their cases decided. Courts make declarations that certain laws are unconstitutional, though the actions or omissions before the courts on petition are contrary to the provisions of the law. A point that I thought this audience should discuss is compliance with the court orders is an issue that we all need to get addressed. Courts may not have a mandate beyond making the declarations and orders. And I'll pick the example of case number 22 of the compendium, which is Amama Mbabazi versus Yoweri Museveni, Supreme Court election petition number 1 of 2016. In their detailed reasoning for the judgment of the court noted that in the past 2 presidential election petitions, the Supreme Court made some important observations and recommendations in regard to the need for reform in the area of elections generally and presidential elections in particular. The Supreme Court made 10 recommendations that needed legal reform before the next elections. There is need for the legal reforms to be done, therefore, before the next elections, and the reforms have not yet been done by Parliament. This is work for Parliament and the executive to do before the next elections. Friends, I think I recommend that we all read the compendium. It's a useful addition to our literature. I thank you very much for listening to me.
That was a very reflective and compelling keynote address. Ladies and gentlemen, another round of applause for the Honorable Justice. I hope we are now set to move, and we are all eagerly looking forward to reading the compendium. With the breakdown that he has given us, I think it has never been more than easy to read and relate with the compendium before us. At this juncture, I'm going to welcome a student amongst us. One of the unique things today we have is that we have a multi-generational, cross-generational audience, and we're going to be having a student who is going to, I'm going to request to introduce herself and present to us. Okay. Oh, yes, you may.
My Lord and guests, the Fidelis Leadership Institute is creating a critical mass of ethical leaders. And this young lady, she's going to introduce herself, comes from one of the schools. And our teacher is over there. Can we give her a big hand clap? That we've been working with. We have launched FAT clubs, faithful, available, teachable clubs in schools. And these young people do ethical elections in their schools. They've committed to ethical elections. I want to recognize the head of Legal Electoral Commission, Ms. Jennifer Ngeo here. We've partnered with the Electoral Commission on voter education, and I'm very excited because these young people have been doing an essay competition on ethical leadership and constitutionalism, and she's one of them.
Good afternoon, everyone. My name is Auma Cynthia Elizabeth, and I'm from KC Primary School, Kamocha. I'm going to recite a poem entitled The People's Voice in Court. In the temple of justice, silent and tall, where statues whisper and gavels fall, there rises a plea, both humble and strong, to right the collective and silence the wrong. It is not the quarrel of neighbors and kin, but battles of comments, of loss or of win. But struggle of many, the voiceless, the small, whose rights are forgotten if right exists at all. Public interest, its noble name, a shield against neglect and shame. When children thirst and rivers die, when freedom bends beneath a lie. See the worker, unpaid, dismissed without care. See the prisoners languished in fatigued air, and widows driven from their land. Injustice wears 1,000 forms, from silent hunger to violent storms, yet public intense litigation dares to lift the veil, and let the truth breathe through the veil. A single hand may pen the plea. Yet speak for an entire community, one citizen's voice, one advocate's pen. Many guard the rights of women and men. The court, thought distant, now but here. The whispered cries, the voiceless fear. Through the writs and orders, bold decrees, it summons states to bend their knees. For law is not a fortress closed, but a living trust the people choose, its purpose higher than private gain, to guard the weak from tyrant's chain. Yet power tempts and shadows fall, ambitions may corrupt the call, frivolous scams may clog the way, and truth be lost in the flood of clay. So judges treat with careful eyes, to shift the fault, uphold the wise. They guard the gate, yet they let it swing. And when the orders breathe the night, the hungry fed, the wrong made right, the people learn without hope anew that court exists for me and you. Thus public interest, bold and free, becomes the soul of democracy, not in the statutes cold and bare, but in the people's right to care. As long as nations dream of peace and human dignity seeks release, public interest litigation will stand, both shield and strong, to right the weak, restrain the strong. Public interest litigation, a hope for the poor and oppressed. Thank you.
Thank you very much for that wonderful poem. I must say it is something that pushes us all to wonder what is our contribution. If a young primary student can write something reflective, something they've thought about in line with public interest litigation, then it must be a wake-up call that each and every citizen of Uganda, regardless of age, gender, is supposed to be paying attention to public interest litigation and being concerned about what happened. So thank you very much, and thank you to your teacher and everybody who supported you on this. Next on agenda, we are going to be officially launching the very first ever in history, in Uganda's history, first compendium on public interest litigation. And I'm going to be requesting Madame Fiona Wall, Madame Anna, the Honorable Chief Justice, Deputy Chief Justice, Mr. Pius, Her Excellency Kaja,
team that we have, if I may call you young. My lord, you will need to cut the ribbon. Wondering how we'll do it.
Do you have the scissors?
Ladies and gentlemen, are you going to do it?
Ladies and gentlemen, on account of, since the 3 decades, so we're going to just count from 1 to 3. On a count of 1, 2, 3.
I'll ask that you take pictures of
Does this mean that whoever read it before it was launched read it illegally? We now have rights to read it.
Yeah, I wanted them. It's my lord would like you to officially. Oh, sorry, our guest of our SG. You're now going to officially launch this. Sorry, declare that it is worthy of our reading. Where is the microphone?
Mark, kindly pass it down on the stool.
We really need the Attorney General's office to say something.
We have them.
Thank you very much. Fiona has told me that this book is worthy reading. So it is worthy reading. So I commend it. We were having a chat earlier with Fiona. And I said that I bet the ones we won are not in here. But we commend them, and I commend this book for everybody to read. Thank you very much.
Now that the compendium has officially been launched, you may now read it. If you had already read it, let us pretend like you had not yet read it, and we can now start afresh. There are flyers that have been placed at your tables, so feel free to take a picture of that flyer, share it on your social media platforms, on your WhatsApp status, send it to your students, to your children, to your family members, to your workmates. It is accessible online through the flyers that have been provided, the small leaflets. So they can just scan the barcodes, and after scanning, they can access it online. So it is accessible to every Ugandan and anyone who has a smartphone and can access it digitally. But with time, there will perhaps be access points, and it will be remade in different languages. Because we are all human, I'm going to request us to take a bit of a break of about 2 minutes to recess So you can stretch a bit, grab a tea, say hello to your friend you've not seen in a while, or make a new friend as we prepare to get back and have the panel discussions. But we can now recess for about 2 minutes. You can use this time to take a picture of the leaflets, share them with friends. You can check on the website of Fidelis, www.fidelisleaders, and at the CAS website, and you can access it. Our tea break is coming to an end. I'm going to request us to get back inside. Welcome back to our last session of today's official launch of the Public Interest Litigation Compendium. I hope we have all had some tea, some break. I hope we have all made a new friend, caught up with an old friend, and we're all ready for the next session. So coming up next is going to be a panel discussion, and I'm going to be welcoming the session chair, Councillor Jane Mary Vianney, to come and take us through the next session, which is going to be a panel discussion. Councillor, you're welcome.
All right. Yes. Okay. I wish to stand on the protocol already established by all the previous speakers. Good morning, ladies and gentlemen. Allow me to invite you to this panel discussion where we shall be exploring how the courtroom has been shaping justice in Uganda by looking at the landmark cases, some that are here and those that may not be here. To join me on this panel, we have 3 distinguished guests. Ideally, they need no introduction, but I will introduce them and invite each one of them to join us here. To start with, we shall be joined by Dr. Kabumba. Dr. Kabumba is a professor. Not yet. Perfect. All right. At the Faculty of Law at Makerere University and the current director of the Human Rights and Peace Center. Okay, thank you. Also, okay, so we are also joined by Ms. Nur Nachibuka, the deputy, yes, executive director of the Center for Human Rights and Development. And lastly, by no way least, we shall also be joined by Council Rakafuzi, Ladauslas Rakafuzi, the founding and managing partner of Rakafuzi and Company Advocates. He'll stay. Okay. Perhaps I'll get him a microphone.
Thank you.
Yes, Dr. Kawumba, I will start with you. And I would like to tap into your experience as a scholar and also as a litigant to discuss what the qualitative measures have been for appeal in Uganda, and perhaps what is that one landmark case that you could say has pivoted our jurisprudence and advanced our socio-economic transformation.
Thank you very much. Good afternoon. Morning. So it's a difficult question. The best PIL case. I can think of a number, including some dissenting judgments. I can think of one attended dissent in the particular case in the Supreme Court that he would have. Apologies. So I was just saying that it's a bit difficult to zero down on a best or favorite case. I was just saying that I would think of a couple of dissenting judgments, for instance, the Gona Ntende's dissent in the Shigula case, in which he would have found the death penalty to be unconstitutional, period, the entirety, not the question of mandatory vis-a-vis discretionary. So it's a tough one. But if I'm pressed, I'd also think of Osotrako, the High Court decision again of Gona Ntende, in which he used the historical analysis to basically argue that sections of the Government Proceedings Act were unconstitutional. And just basically the way he traced it, I'd think of Stephen Kalali versus Attorney General, prisoner's right to vote. But if you press, then it must be, I think, Dr. Adrian Juko versus Attorney General. Because I think it speaks to some of the concerns or the questions the German ambassador expressed in the forward, and which Anna highlighted this morning about where is the public in public interest litigation, and questions around the democratic legitimacy of this project. If Parliament has made a law, who is a petitioner, or who are 3 petitioners to go and strike down a law hundreds of members of Parliament who are elected made? And I think the Dr. Adrian Juko case answers that question in a very powerful way. That case challenged Section 15, clause something, I think either D or E, of the Equal Opportunities Commission Act. Noor says it's E, which basically said, which forbade the commission from inquiring into any matters which were not accepted by the majority of cultural communities in Uganda. So a clear appeal to the majority in the act itself. And even the debate in the Hansard revealed that it was specifically meant to bar certain Ugandans from approaching courts, or approaching the commission. And the Constitutional Court unanimously, and the panel was headed by the DCJ Emeritus, found that section was unconstitutional, it was inconsistent, and I think this is Ladislaus Rakafuzi's case. So again, I think we owe you quite a lot for your work through the years. Incidentally, okay, so the panel said that provision was inconsistent with that basic human rights, Article 21, right to access to justice, etc. But for me, that case is important for two other reasons. Number one, the use of the term citizenship in the court's decision. Because it said one of the problems with Section 15 was that it created a class of citizens, those who could approach the court and enjoy rights, etc., and it's another class of second-class citizens. And for me, it brings to mind questions around, for instance, other classes of distinction, race, for instance, and the infamous Dred Scott case and others that had also similarly created distinctions and had declared that black people in America could never be citizens. So for me, the case is important about the question of citizenship. But secondly, I think it answers the question around majorities. So here was a court, 5 people, saying what the Parliament of Uganda had done in their majoritarian sense as elected members was inconsistent with the constitutional principle, and struck it down. And really, is that not the point of a judiciary? to act as a check, even against the expressed wishes of majorities, and to hold them faithful to principles and standards in the Constitution. So I think for me, that would be the case. And if just 1 minute, I'm sorry I've taken a bit too long, is that it's that kind of case and that kind of approach that I think is important and that has been replicated in some other decisions. So Stephen Kalali, about prisoners, that the fact that you're in prison doesn't take away your citizenship. Again, for me, that's the issue. Opio versus Obote, High Court decision, Judge Mubiru, about imprisonment for debt, civil imprisonment for debt. Again, the suggestion that simply because you owe money doesn't mean you should lose your liberty. So for me, that decision is important for the point it makes about the Constitutional Court, its role, its situation in separation of powers, but also the idea of judges sticking up for the vulnerable, for the weaker. And unfortunately, the Adrian Juko case has somehow disappeared from in our jurisprudence. And the Constitutional Court seems to have forgotten it in a number of cases that have come up, and I think that's a very sad thing. Thank you.
All right, and right there, I wish to also inquire, what other measures, if any, should we consider as we profile, as we compile, in measuring what successful or unsuccessful appeal is?
It's on, eh? How can you tell? Is there a red light above? So I think that is the difficult question, and I suspect that those who compiled this compendium must have struggled with that. What do you choose? And I think the Solicitor General, hinted on this. Because even losses might be success in the long term, to put on record the struggle. And some wins might be losses to the public. Because again, not all cases brought as public interest litigation are really brought for the sake of the public. I can think of one case, for instance, Surion Konkem and Kwangamao versus Attorney General, that really was a fight, a family fight that was involving some elements of the use of criminal law to try to score points, and I suspect that petition was brought to delay the criminal process. So it is a difficult point, I think. But I think the point the DCJ made is an important one also, that in PIL and in constitutional petitions, we have to separate the petitioner from the petition. It can be the worst person in the world, and or the most manipulative person, or a business person who just wants to use the Constitution to protect, and that has happened. BAT versus Attorney General was BAT trying to use the language of the Constitution to basically stop the Tobacco Control Act from being enforced. So it can be the worst person or the worst company, but if the principle is there, if the Constitution is being asserted, if it gives a forum for the court to express itself as what the Constitution is, then I think that is also success. I don't know if I've answered the question. I suspect not. But for me, that's really the idea.
Thank you. Over to you, Noor. Okay. And Noor, what I would like to discuss with you is the SEHAD petition, the petition you handled, involving maternal health, access to maternal health services. The political question doctrine, what is political, what is justiciable. How do we draw the lines going forward? We have, for example, currently discussions on judicial activism, overreach, perhaps by the judiciary into certain territory that should not be theirs. What considerations as a peer practitioner, what considerations should we have? What distinction should we have? Is judicial activism dangerous? Is it necessary? Your thoughts?
All right, thank you. I'll just give just a background to why that case was actually filed. The time of filing that case, we had several considerations. First, we noted that the country had very good legislation in environment, and I think that Team Greenwatch, had done a lot of work on environmental law, and I think we had precedents. But the question that we had before going to court was, where is health in our constitution? The world read the right to life under 22 would be the same way one would read health. And we noticed that very many players had done what they did. You know, Parliament had made laws. I think our Public Health Act is now amended. Then it was a 1935. But the questions that we had were, who is challenging the government on issues of health? So we went to the Constitutional Court on several things, but one of them was to see that we place the right to health in Uganda's constitution, which the eventual judgment that the compendium does not speak to does. And the second thing was where the people in all this. So you'll notice that at the onset of filing of that case, again, I think the country was trying to do some bit of constitutional amendment. So it was right time for us to bring it up as a constitutional matter for interpretation under Article 137 of the Constitution. And the questions we're framing were, why do women die while giving birth in government health facilities? Why would they die when the basic reasons they're dying is because they lack maternal health commodities? So when you move to court, it quickly picked up with the public. I should say I filed it myself. Then I think we're around Parliamentary Avenue, and the journalists in the room were asking, are you sure you can sue government over women dying? And I was like, well, let's test it and see. And that's how it picked. Before you knew it, it was appearing before the first page of New York Times. And we saw journalists coming in to fly to Arua and Metiana, where we picked two of these cases to actually pick it on as an institution that is challenging the government. Of course, it took time. And not the very first appearance, because we were in court for more than 8 times, and either the panel was not, we didn't have enough judges quorum, or the representative of the Attorney General was not available. And the first time we appeared, what happened was a raising of a political question doctrine. We were told that what we are bringing before court are not matters of court. If we needed to have laws, policies formulated, or budget, we were in a wrong space. And we felt it and said, okay, what the court brought out was the doctrine of separation of powers, or the political question doctrine, to say, as the judiciary, we cannot be coming up and saying what the legislature should be doing is what we should be doing with the executive. Each of us, the 3 arms of government, have our own powers. Therefore, you're before a wrong team. When we sat down, we thought first, this was a very wrong decision on the books of the country. We couldn't set such a precedent, because it would mean that while the country had moved forward with public interest litigation, and the public would always come in to use it as an avenue to have their rights realized, this particular judgment was blocking them. It was going to be a very long one for the country. So when we sat down, we said, but why would the Constitutional Court run away from its powers and mandate? Because we were running through Article 137 of the Constitution, and we knew that they actually had the powers. So we thought we needed to go to the Supreme Court so that we actually have this away. The compendium does not have this second part. When we went to the Supreme Court, again, we raised questions of the Constitutional Court is running away from its constitutional mandate. What we needed from court was an interpretation that by women dying the way they were dying in public health facilities, it was violation of their rights to life, to health, and therefore sought compensation. Of course, when we moved there, the question they asked us is, why don't we go under Article 50 and have rights enforced? But by that time, we had another case, the famous Nakaseke case, challenging local government and saying, this is it. So what court was telling us to do, we had already done. But the most important thing is that the Supreme Court actually realized that if we leave such precedents in the country, it will be barring people from accessing rights. So the Constitutional Court was very vocal when it actually did pronounce that the Constitutional Court should hear the case on its merits. And around 2023, I think, we then get a positive judgment. I think while I'm not asked this particular part, I'll just request that I continue that when the former DCG was speaking here, the first request was a question that he asked us to think about was the question of interpretation of the judgments. I must say that this judgment is one that has been implemented by the government 80%. If not 90%. The only pending thing in that judgment is the compensation of the 2 families of Rhoda and Nziko Valenta in Arua for non-payment. All the others, it has done. It has trained health workers. It has presented before Parliament a maternal health audit report on why actually women die, and we have seen these reports. It has tried minimally to increase the budget for health. Very minimal, but a progressive step because we are tracking what government is doing. And that is quite important, even when at the moment we are looking at infrastructure, not yet human resource. That's why our health center twos are becoming threes now, partly because of this case. We feel like we are moving. And I feel like our reduction in maternal mortality, for example, in the country from almost 336 to 189 per 100,000 live births is a huge step. And I think the trick we have done is a trick that the late Justice Kenneth Kakuru told us in one of the spaces like this. When we invited him, he told us that keep strong, but build one brick at a time. And that building of a brick is not just for the lawyers, but also for those who are actually ensuring that these judgments are implemented. So we just said, okay, we have sued your government, but here we are. We want to work together to implement. And I think for me, that is one strong thing that says you can actually dialogue and dissent with the government if it should be the way to ensure that people's rights are not protected. So in terms of public interest litigation, yes, it is an approach that is very good, but it's protection. If we had not appealed that judgment, the protection would be not there anymore. Perhaps we would be saying, oh, we had it, or the Constitution have it, but courts would not be able to enforce it. Thank you.
All right, thank you. And right before I leave you, specifically as a practitioner, on the question of sustainability, regarding the challenges that litigants face, issues of costs. I know that CSO actors rely a lot on donor and development partner help. And so the sustainability of PIL as a tool, especially in relation to how costly perhaps it is, as Ms. Fiona said, they are going to try and roll out the tool to people in different languages. But how do we sustain it as a very potent tool, looking at the challenges that litigants face, especially the question of costs and the time that these cases take in court? Yeah.
I think what I should say is that partners love so much the result, but not the process. The litigation process is extremely long. Us who have been funded by very good partners, they come with projects. The beauty is that they let you think what you actually want to do, but projects come and end. The very first partner that supported this case gave us $8,000, and they did not give it to SEHAD as an institution. They gave it to the founder of the institution to do some research, and we turned it around to a case. That partner has since closed. Open Society has since closed. But so many years later, this case took us 9 years to be litigated. I think in terms of sustainability, the first thing is to hold your client as very valuable, because the moment the client loses interest, what would be your interest in the matter? Unless if you're going as an institution and not clients. What we have learned along the way is also to go as an institution, because when you move with people, they lose it eventually, and they feel like, we can't do it anymore. So the trick that we are using of late is to have them append affidavits, evidence, but not as a party. Even if they lost it as a party, their evidence is already on record, unless if they died, because we have one where a person died and it's a challenge. So the bit of sustainability is that. But also the courts need to open up, because lately we are being asked about the human face. Where is the human face? They expect that if you're bringing such a case, you're actually moving with the files of the ladies or gentlemen or families that actually struggled. So the courts need to open up to know that the Constitution does not say that when you're coming, come with a person. It's open. Any person, any institution, So if it is that, then courts have got to open up in that way. That's one bit of sustainability. But also, too, I think we keep telling lawyers, love what you do. Because you are the ones with the expertise, and you are the ones to represent the people. For as long as the people still believe in us, we'll have PIL sustained. The third thing is, do not just litigate and leave it at that. Because we have that tendency, not me. We, the lawyers, have that tendency that the moment you win in court, that's it. The only thing they want to hear, if there are words, for them to go and actually follow the money. But who follows the other declarations that are made in these judgments? And for me, if we pull those up, it actually means that these are bits of sustainability. When Fiona was presenting here, she spoke about how many cases that we have challenged legislations. And I kept asking, okay, does the Uganda Law Reform Commission know this? Does the first Parliamentary Council know these things as they amend the legislations? Because that's when we are going to come and say, oh, we can sustain this. In this case, this happened and we are here. We have one where we have challenged the Penal Code Act on calling people with disabilities as idiots, imbeciles, and what. It was actually the very first case before this petition. We have moved with the first Parliamentary Council Law Reform Commission, and they're not acting to amend the Penal Code Act. When we opted to amend, we're amending, what they call bail terms. That's what our focus was. So our sustainability needs to move beyond what we are litigating as political face of it towards what is for the people. And for as long as we have the people for us, I think it makes things then easier. In terms of the money, the environment is changing. And the most important thing is for us to hold our constitution as the supreme. And when we do, the money will have nothing to do with us. Thank you.
All right. Thank you, Noor. I'll move over to Council Rakafuzi. And Noor here has mentioned the impediments the legislature and executive face or pose in implementing some of the decisions, the fruits of litigation. She mentions 80% success, but for example, in some of the cases that are cited in the compendium, especially those to do with electoral reforms, there are little gains in terms of enforcement of these decisions. What are the structural impediments, and what do you think the remedy? What remedy should, what tools should be adopted in order to ensure that in other areas success is also achieved at almost same wavelength here?
Well, I'm very glad that she's very positive about gains. I'm very negative. I'm sorry. My experience is that the Attorney General or government does not take these cases seriously. And the Attorney General is always a party to these cases.
But
Just a minute, Council. Just a minute.
The Attorney General is always a party to these cases. For example, let me talk about what I've been involved in. I've gone to court to challenge the lack of sufficient judges at the different levels of the courts, magistrates, High Court and the Supreme Court and the Constitutional Court. I've challenged this in the East African Court of Justice as a public interest matter. We have a problem because cases take so long in court to be litigated, to be completed, because there are very few judges to complete these cases. I've litigated this, and the Attorney General has said that in defense that they don't have enough money to appoint enough judges. The Constitution is not very clear on what happens. The Constitution says that at least appoint acting judges when the situation is so bad. At least appoint acting judges when the situation is so bad. So it means that there must always be enough judges according to the Constitution, but the government does not take this seriously. I know people who have been affected by lack of judges. I have clients who have been in detention, who had been in detention for 12 years without trial. They dangled amnesty over their heads, and one of them told me he had a younger wife, so he accepted to sign for amnesty. He was granted amnesty. So they knew where he always was because he had signed for amnesty. So when something happened when we lost the Assistant Inspector of Government of Police, they looked for these people who had signed amnesty and arrested all of them and charged them with the death of the Inspector General of Police. Yet these people, they signed amnesty because they had not been tried for many years because of being on detention for too long. They arrested them and tried them. Now many of them have been in detention for many years. I can point out about one man called Abdul Rashid Mbazira. This man has really suffered, has been in Luzira for many years. I think most of his years as an adult. So I took this matter to court. The Attorney General said that they don't have enough money. So what do we do in such cases to make sure that there are enough judges? Well, the Constitution says that Parliament must, for the High Court, Parliament must make a resolution for the increase of judges, and once that resolution is made, then the government must increase the number of judges. Then for the Court of Appeal and the Supreme Court, the Judicature Act must be amended. And that is for government itself to bring a bill and for Parliament to pass the bill in amending the Judicature Act, increasing the number of the judges of the Court of Appeal and the Supreme Court. So you people, there's a lot of injustice. Some people are really suffering. You see, the legal process is very burdensome. The legal process is a kind of due process by which a person is arrested and he loses his liberty. When that person loses his liberty, is entitled to be heard as soon as possible so that he can regain his liberty, or he loses it on grounds that are very clear to the public. So now the legal process is being abused because of lack of sufficient judges. Well, I'm not saying that I don't want to become a judge personally. I am just saying that we don't have enough judges. We need judges so that people who are in detention are able to get justice. Then another problem where the government is not taking its mandate seriously. For example, under Article 23 of the Constitution, it is said that the writ of habeas corpus shall be inviolable. So they are supposed to create offenses for people who violate the writ of habeas corpus. Those offenses have not been created. So habeas corpus is not taken seriously. Yet actually, it's a very fundamental thing for the rule of law. Another thing is that government itself was mandated to bring a law for the enforcement of rights and freedoms. That law has never been brought by government. It was brought by a private individual in Parliament, and it was not comprehensive enough. The way it was drafted, it did not it lacked what was really envisaged in Article 50 and 51 of the Constitution, because it should have been brought by the Attorney General, and what is very unfortunate is the Attorney General has gone to court to challenge that very act he is supposed to have brought himself. So, for us who are involved in public interest litigation, we have a problem. Government needs, I don't know whether we need to have tea with the Attorney General and discuss these matters with him, but of course he is just an employee of government. I don't know if that is sufficient to have tea with him at our own expense. But what do we do? Because we need laws for the enforcement of rights and freedoms.
All right. Okay.
That is my experience.
Okay.
Otherwise, if I tell you more, we shall have to sleep here. Okay.
All right, thank you, Council. I want to get back to you, Dr. Kavumba, as we conclude on the question of judicial independence, particularly in cases that are considered political. Yeah, there's a general feeling that there is no independence when such cases are brought to court. It's creating a bit of apathy among litigators. What can be done to ensure independence, or perhaps erode that perception when cases of political nature are brought before our courts? Yeah.
Thank you very much. Since I'm concluding, I think let me just make 3 quick points. One related to what Senior Counsel Ladislau Kafuzi has said. Of course, it's a difficult question, the question around sufficiency of judges. I hear some colleagues talk about mission-based judges. I'm not too sure about that personally, because I think there might be danger in exacerbating the problem, because you have people who are there on a short-term basis who may then have a very short-term interest and respond to that short-term interest and create a whole man of a mess. So I think maybe there might just be a need for a serious overhaul of the judiciary, including maybe structural changes. For instance, I know the Constitution talks about Article 137 constitutional interpretation being only for the Constitutional Court, but maybe it's time we devolve it, that jurisdiction downwards to the High Court, as is the case in Kenya and many other places. So there might be some structural ways, or even I think one of the reforms being contemplated is increasing the jurisdiction of the chief magistrates, for instance, maybe to 200 million or 250, given inflation. So it might be that we might have to have a longer discussion around how to solve the problem of the adequacy of judges without creating another problem. Now, but still on that point, it's one thing to have enough judges or enough courts, and I think that's something the judiciary has been very keen on, putting up structures. But I think there's another problem as to what you find inside there. What is the nature of the judicial officer you find in the court? And I think, unfortunately, I have to say increasingly, there's a clear distinction between the judiciary of 1995 and, it must be said, the judiciary of 2025. I think 30 years down the road, there has been a clear diminution in terms of both competence and commitment and character. There was a time when you appeared before a judge and you trusted that even if you lost, justice had been done, and that's a very good feeling. It's very terrible if you don't even want to appear before the judge, because you know that if it's that judge and this is a matter involving, and that is a very dangerous situation, because once citizens lose confidence in the third branch, where do they go? Where are you telling them to go? That is really dangerous. But related to that is, okay, a certain apathy, I think, also on the part of the bench. I don't understand it, but it's there. A certain lack of creativity, a certain lack of... So the DCJ referenced Justice Luga Kingira of Tanzanian High Court, and I think the case he was referring to was Mtikila. And in that case, Justice Luga Kingira actually said that he described the situation in Tanzania, its long rule under one-party state and its history of poverty, illiteracy, disease, and he said that because of those conditions, Tanzanians had become apathetic. And that it was because of that context that if there was a public interest litigation, a public interest litigant, he said, and specifically Judge Lugangira said, the courts must rise up and grant him standing. Now that is a description of an activist court rising. There's a description of an active court rising to meet the litigant because of the context, because not everyone is coming, because some have their rights violated and they don't have the means to vindicate them. Some are doing the violation, so they don't come, or there are some active obstacles. So once someone breaks through and comes, it is an active duty of the court to be different from a normal Vianney versus Noor. Unfortunately, that's not happening. It has been lost. So one of the dead articles, in actual fact, is Article 126, Clause 2E. In fact, our colleague Chirunda wrote his dissertation, LLB, on the death of Article 126, Clause 2E, the one about substantive justice being done without undue regard to technicalities. Now, I know the time is, but this is just 2 points, really. Incidentally, I also wrote my LLB dissertation in 2005 on public interest litigation and human rights. But you see, in 2025, there are decisions now from the Constitutional Court, in which the court talks about, for instance, the presumption of constitutionality. Now, it's bad enough that you're not using Article 126(2)(e) to grant, to decrease local standing, to be more flexible. But worse, you're creating presumptions that heighten, that increase the threshold that a litigant must jump. So the court is not reducing the barriers, it's creating barriers that are nowhere to be found in the Constitution. And that, honestly speaking, it's an abdication of judicial responsibility. It's terrible. And so incidentally, Fidelis, my recommendation might be, this compendium is very good. But maybe we also need a compendium of the worst cases. The worst cases, and there are so many now. I think there are more worst than best. So I think we need and those of you find like 100 or maybe thousands, I think you'll spoil for choice. Because there are so many, and I think it was said at the Ben Kwanka Memorial Lecture by Gimara, Senior Counsel. He said, and this is why it becomes very, very problematic, that High Court judges are issuing precedents they know are terrible. Then they cite themselves to create an environment of legitimizing those precedents. So it becomes a vicious cycle. Now that's really terrible. And that's at the High Court, increasingly it's at the Constitutional Court, and soon it might come to the Supreme Court. And Fidelis, it's difficult work, but it's as important as this particular work. Finally, I see you're going to want me. Related to the first 2 points, finally, the courts, of course, are talked about publicity interest litigation, and there's a concern around civil society actors using PIL for publicity. But I think if you do a cost-benefit analysis, there might be more benefit than harm, really. You may want to, something may be in it for you, but if the Constitution is implemented and is given light, maybe. But what's more dangerous, and I think Councillor Rakafuzi has spoken about this, is a more insidious development, which is state interest litigation brought by private actors, ostensibly. And I think the case of the Human Rights Enforcement Act is an important one, because evidently it followed some comments made by the Attorney General, and a few weeks later, conveniently, there's a petition brought by an individual challenging the Human Rights Enforcement Act in respect of some of the things that go towards non-derogable parts of the Constitution. Now, courts again, but I don't really know, because courts then must be clear as to what's happening and try to respond to that. Civil society must be clear at what's happening, but how does the judiciary that doesn't know what it's doing respond to such sophisticated mechanisms, more dangerous mechanisms? So honestly speaking, when we talk about a judiciary in crisis, we're not being, what's the word, what's the English word? It is not an exaggeration, but it's a real thing, and we need to address it. I'm sorry, and I apologize for taking so long, but I think that's the picture.
Thank you. Noor, your parting shots and what you think the future of PIL is.
All right, thank you. I think for me, I would think that we are a generation, and we are going to live tomorrow. But what are we sustaining and nurturing for tomorrow? The power is in our hands today, and we can only do much. I feel like what Dr. Kabumba is speaking about are things that we need to start questioning for the future of tomorrow. The journey of PIL has been a journey. When you read what Professor Mbazira keeps writing about PIL, several of them, you're actually going to realize that the way we are engaging PIL today is very smooth. It's not the way it used to be, of present you're affected by a specific person and all those things. It's like it's very smooth, and the Constitution has given us that. And our protection of that is quite important, because you're laying strategies for the future. So I have a feeling, or I would say that let's bring the public to understand the issues, and I'm glad we are putting this in languages that people can actually access. But it's still too loyalistic for an individual to read and understand. If we can only simplify it, then it means that we are building onto the blocks of PIL. At the moment, in my view, a non-lawyer would struggle to even understand some of these things. But when we're discussing here, we said, let's have it for the non-lawyers and the lawyers. So I would think that giving it to a non-lawyer to simplify it, what does the case I don't remember what cases are there. What does Salvatore Abuki mean? Not in the legal language. And I think for me that would mean that we are putting PIL together. And we are discussing PIL, but not even explaining what PIL is. What is it in a layman's person? How do we make sure that the people that are supposed to utilize it actually utilize it? Maybe time will come when the lawyers' jobs are done and that people, we had actually started seeing people moving to court, even today they move. Maybe they will see an issue and say, while I'm not a lawyer, I can actually take this to court and try to show the judges that this is it. But also let's more and more, in my view, bring the judges in these rooms. Because what I studied in law school and what I see in practice, some things are totally different. So creating spaces for the judges to learn. When we do our inter-university law moot constitutional competitions, initially it used to be us and lawyers judging. Lately we go as far as the Supreme Court to pick the judges. The reason is not for them to say judge this person, but also understand the things that are happening today. Maybe when they do, we'll get to where I want us to get. To bring them to the faces of the people so that when we're litigating, they're also listening to the issues of the people, not the way it has been politicized. Thank you.
All right, thank you. Ladies and gentlemen, that is all that we could afford within the time that has been allocated to us. Thank you for being a great audience, and thank you to the panelists. Thank you.
Thank you very much, John Mary and the great panel. I'm going to kindly request you before you leave that you take a group picture of the panelists. Is that accepted? Yes. As they take the picture, a round of applause to congratulate them and thank them for the great work they have done. Just a minute, just a minute. Can we have Anna and Fiona join in? Oh, it's well. Thank you very much. Next on agenda is going to be another panel discussion that is going to be expounding more on the contents that are in the compendium. So ladies and gentlemen, allow me welcome a gentleman. He is a doctor academically, a senior lecturer and head of Department of Law and Jurisprudence at the School of Law at Makerere University. He's also the coordinator of the LLM program and the patron of the Mood Society at the school. But most importantly, ladies and gentlemen, he says he is a Christian, and he said that should be said in capital letters. So join me, ladies and gentlemen, to welcome Dr. Daniel Ruhweza to take us through the next panel discussion. Doctor, the house is now yours.
Present a paper. I'm just going to moderate a conversation, but a lot of money was put to bring this here. And so let us make use of it when there is still a chance to do so. All right, so good morning once again. It's always a pleasure to be part of conversations like these ones. I know that we get to learn a lot when we meet together, when we discuss, and so I have a lot of respect for our senior members who are here present, our funders and partners, our former lecturers and mentors. I respect all of you in your various capacities. The second panel that I am going to moderate will be looking at from courtroom to community, using the public interest litigation compendium to drive accountability, reform, and civic education. But before I invite them, can I make 3 points? Is that okay? It's not a keynote address, I promise you. Point number 1 is for us to remember that everything we are doing is in the interest of this thing we hold dear, which is not necessarily the Constitution, but constitutionalism. And that with constitutionalism, we are very concerned about the people, what the people think, how they want to be governed, and therefore in our response for this session, I would really want our panelists to not forget constitutionalism and how constitutionalism is supposed to be the bedrock of our conversations, how people move, how people decide, how people discuss, and even when we are holding those responsible in that regard, we should remember constitutionalism. Point number 2, I feel that this conversation is very esoteric in that it has brought the known parties to the conversation. All right? I can see my senior lecturer whose notes in constitutional history we've all benefited from. I think he knows all this information from head to toe. Senior Counsel Rakafuzi and others. But I would like to suggest to Fidelis and to our funders that this conversation needs to step away from this very beautiful hotel and go to those people who do not understand what we are saying, who when they see us wearing these neckties and specific dressing, immediately will call you counsel, whether they think you're a lawyer or not. And so the conversation must move from that space, and we hope that this discussion today will be a foundation for leading us into that space. Lastly, I would like to suggest that this compendium, really it is to confirm the words that have been spoken by one of the panelists, that this compendium must be taken back to a specific group of people who can then convert it into language, or like Senior Counsel Rakafuzi used to do, into drama that we would watch. Those of you who probably don't know, Senior Counsel Rakafuzi used to run a drama series on local television that would analyze some of the basic legal concepts in art form, and that communicates. So Fidelis, Fiona, do not stop here. This is beautifully written. I must say I love the design and everything, but I would like us not to put it in our bookshops or in our bookshelves, but let us keep this conversation going. I know through poetry, some of us are poets. Kabumba and I, we've done poetry. Among other things, artwork, having a conversation about how do we draw and paint these concepts into being, so that people who are not necessarily going to sit where we are seated today can also engage with this very important work. With that said, allow me to invite our panelists. Thank you, Kenneth. and you're the first panelist anyway. Kenneth Muhanji is a friend of ours, and he is a lawyer in practice, very passionate about the things that we are going to talk about. He's a partner at KTA, and I love his passion for the use of IT and ICT, probably interrogating AI as well. It will be interesting to hear his views on how that can also help us in this regard. Kenneth, you are most welcome. Panelist number 2 is Dr. Honoria. Dr. Honoria, Dr. Honoria was my lecturer, and I'm sure he taught many of us who are here. Or if you haven't engaged with him, I'm sure you have heard about him in certain spaces, including his famous notes on constitutional history. Dr. Henry Honoria is a senior consultant in many issues to deal with governance, constitutionalism, and the like. Very, very happy to have you. Right now, I think he's still chairing the staff panel, the staff appeals panel at Makerere University. So hopefully, when we read your jurisprudence, we shall be able to see how much constitutionalism is being done and applied in your decisions. But we've seen some already, and we are grateful. Aaron Kiza. Aaron Kiza. Those of you who don't know Aaron Kiza, in my local language, we say, I jebale you, because clearly, if you don't know Aaron, Aaron is passionate about the environment. Aaron Kiza also is a recent graduate, yes, graduate of August of the prisons in Uganda, and he's been passionately defending, among others, Dr. Kiza Besije and others. He's also a renowned poet. He's done a bit of poetry, not a bit, a lot of poetry. Aaron is also, as some of you might know, very passionate about the issues going on in Uganda Law Society. So he will say a little bit more about that if that chance comes. And last but not least is Dr. Hassan Shire from Defend Defenders. We'll probably have to find a way to seat you. Yes, there's a chair here, so that you are able to speak to us. I was whispering to Fiona Wall that I wanted to add a lady to the panel, but I know it will be an overkill. But just know that the feelings I have is for Dr. Barrier to be here as well. Jennifer Barrier. So Jennifer, prepare. I'm going to ask you a question. Even if you are not on the panel, I would like you to share some views. If it was not for that space, you would be seated somewhere here. All right. So from courtroom to community, using Peel Compendium to drive accountability, reform, and civic education. Before we ask the first question, I'll ask Dr. Honoria in a sentence or two, what is your take about this compendium? First of all, before we even get into the nitty-gritty. A comment on the compendium, because I know at some point a while back you used to do a sort of compendium of cases that he would publish in the East African Journal of Peace and Human Rights. The microphone seems to be off. Should he press under? Okay. Oh, very good. Yes.
Well, it seems to be struggling with technology. They become more nuanced each time. Who thought the button would be at the bottom? And so thank you, Dr. Weza. Yes, compendiums. A very useful information tool. And you are right that I used to do those reviews of each year human rights decisions. And that shows you that this is timely. It may not cover all the cases that have been litigated in the 30 years, but has picked on the important ones that have sort of shaped the trajectory of the Constitution. And I think this is something that can be picked up And just to probably offer as advice to Fidelis is maybe as you think of a second issue or further issue, editions of this compendium, think also of doing an annual, I don't know how to quote it, annual review of like the way I was doing those cases, so that each year you have something that comes out that indicates, okay, for this year, these are the cases that have come through, and it then informs what is the trajectory. But it also helps that it becomes a tool of making sure that we are tracking cases as quickly as possible, but also then it makes it much more easier to, how would I call it? It makes it much more easier to a quicker read than a 300-page or 100. So, and then also people need that memory that each year this happened. It also helps it to track the cases. When I was going through the compendium, I realized there are cases which, and I'm glad that you did the intersections, like for instance, between Kivumbi and the Human Rights Network. But there are those cases which you get lost because if you are not following this critically. But I'm hoping that that is something. But it's a very useful resource to have a documentation of matters on the Constitution. And this, I think we need, I don't know how you are going to do it. We've picked those ones which speak to democracy. But there are others which probably speak to other issues which were not addressed. So that's where a more annual process would probably be of great benefit to not just the readers, but also the public.
Thank you very much, Dr. Honoria. I'll go to Aaron Kiza. Aaron, in her foreword, Fiona Wall makes a very interesting comment. She says the compendium is more than a collection of landmark decisions. It is a chronicle of courage, resilience, and the transformative power of law in shaping Uganda's constitutional democracy. My question is, in your view, do you agree? First of all. And secondly, how would you define or measure the success of and the impact of PEEL in this season that we are talking about?
I hope I get it. Is it right? Are we on?
You're on.
So thank
yes.
you very much. It's 2 or 3 pregnant questions. The transformative power of PEEL. Potential, of course, that is axiomatic. You can't debate the potential for PEEL to transform society, but where has PEEL transformed society? In East Africa, you look no further than Kenya. In Africa, the best example is South Africa. World over in the developing country, it is India, for you to make a sense of what PEEL can do for the country. PEEL does not transform societies in military dictatorships or even in dictatorships of any kind. So PEEL is designed to work in a democracy, as part of separation of powers, where judiciary is independent, where judiciary works, where orders are respected. Where there is a challenge of governance and democracy, PEEL now becomes what you may call warfare, wielding the power of law to push back against social injustice, all sorts of injustice. But in Uganda, one of the cases that at least attempt to highlight the magic of PEEL to ordinary people is the ex parte matovu. If you remember, is there a Ugandan who doesn't, or at least a Ugandan lawyer who has not heard of ex parte matovu? It was a simple habeas corpus application. But its contribution to liberty over the years has been monumental. at a jurisprudential level and at a level of inspiring legislation and the level of hope for HRDs. People remember Susan Chigura case. Susan Chigura case, what it did for the right to the dignity of life and so on and so forth. They talked about Lee and Yon. You know the environmental cases that the late Justice Kakuro so prominently contributed to. Philip Karugaba is with us, and so on and so forth. So peer potential is great. Even, of course, in challenged countries like Uganda, still peer works, but it works better where constitutions are respected. So in East Africa, Kenya has a better judiciary, better constitution, and peer is working. The same story with South Africa and Botswana. What was the second part of the question?
No, that is sufficient. I will not, I will not put you to strict proof. I think you have fundamentally answered what I wanted you to talk about. Kenneth, I'm coming to you. But as you prepare, I would like to ask Dr. Hassan Shire a question. Dr. Hassan, I know you are with Defend Defenders, and how I wish we knew you were there in 2016 when we decided to take on the prosecution against the former IGP at that time. We went very naively. But we licked our wounds at some point, and we are still alive. Dr. Hassan, when you look at Peel and the compendium that is before us, of course, you probably may not have read it to the last bit, but in actual, observable, accountable ways, has there been any improvement to civic life at the community level as a result of Peel?
Thank you. I should say that I've seen it this morning. It means the opening. But I want to start, if you may allow, to say well done, Fiona Wall, and her team in making this effort the first time compiling a compendium of this nature. And my thinking is that the cases which are being mentioned within it is worth Ugandans to pursue and to celebrate, because of it holds some sort of space, civic space, whereby actions can take place. I want particularly to celebrate a case here in Beach 97 of Kasia and David and also Pepe, who bravely went to the court when their lives and the lives of others have been challenged by a tabloid newspaper, Rolling Stone, not to be confused the one in UK or United States, but the fake newspaper which just came out to blackmail people of their sexuality, of their family, and of their, how they look and how they dress. And that judge, he made a very brave declarations whereby he upholded a protection to all equally citizens of Uganda under the law. Universal protection of the law to all the Ugandans, and also fought back discrimination on the basis of assumptions people. And I want to celebrate also Rakafuzi, who is right here, and chapter 4, presented by another colleague, Bikin later. He's here now? Okay, good. Rakafuzi, and now we have other lawyers who have taken now the mantra, what you used to do alone in the court of law, representing unpopular cases, cases which other lawyers may find stigmatizing by their other client or the society. Therefore, they shy away from that. Dr. Rakafuzi, he never shy away from that. And he made a lot of success. Previous case on this was Victor Mukasa, I think you may recall, and Pauline, and the state attorney general. And it was related to right to privacy of, just police, law enforcement coming arbitrarily and breaking your home in order to check the occupant of the house. And that was another milestone where, Rakafuzi, you represent that case as well. It was another milestone whereby a privacy, right to privacy, have been maintained by the court of the law of your country. So I think we should be celebrating. I'm sure Aaron Kiza will be having soon cases to celebrate as well because of the amount of energy he devotes on, equality and freedom and the rights of others. So to me, it's celebration because of you have done excellent work and Ugandans have to take. But my purpose today, if I may add what I came for, is to take, or maybe I'll have second chance to talk. Yeah, if I may add for, is to bring out Ugandan here to litigations beyond your country, whereby success, and of course some failures, but success can be achieved. And I want to point out two particular cases. Those significant cases include one defendants have taken to the African Commission on Human and People's Rights against Sudan. As you may recall, when al-Bashir was indicted in 2009, a great number of human rights defenders have been rounded up and tortured, really tortured. And they came through the Nile, some of them virtually swimming or taking the boat to Uganda to heal, recuperate, and relaunch themselves. And three prominent ones, Mul'im Al-Chak, Osman Humeida, the late, and Amir Suleiman, who is also still here, and others have taken the matter through defenders to the African Commission, and pronouncement has been made. Osman Humeida and others with Sudan, the African Commission on Human and People's Rights found Sudan guilty, violating the African Charter due to arbitrary arrest, detention, torture, harassment. As a result, Sudan was ordered to compensate the complainant and conduct investigation into those responsible for these violations. One more minute, and I stop here. There is a journalist called Lohe Issa Konate, with Burkina Faso. That was the African Court on Human and People's Rights in front of it against the Burkina Faso. The court mandated the abolition of imprisonment. No, the case was also taken by defenders, and it was imposed disproportionate penalties that infringed the freedom of expression. The court stuck down and also awarded the journalist in favor of his freedom of expression. I stop here, thank you. So when national litigations fail, I think there's a recourse, because Uganda is a party to this, to the African Commission, regional and international litigations wherever it's available. Ugandan activists can go and petition at that place. Thank you.
Right, thank you very much, Dr. Hassan. Being the academician that I am, I will still come back to you because you've not answered my question. The two cases you have cited, yes, decisions have been made, but I still want to ask the question, has there been actual observable impact or improvement on civic life in those two cases? So I'll be coming back to you. In the meantime, I would like Aaron and Dr. Noria to also reflect on that question regarding actual impact on civic life in the cases that you know about or the cases you've litigated. But let me come to Kenneth. As you see, I'm a very, very fair moderator. I give you advance warning so that you moderate, you think about it. Kenneth, and Dr. Jennifer was not joking. I'm coming, so prepare. Kenneth, The compendium captures historical victories, but accountability challenges are rapidly shifting. Is that me? One of the microphones, okay. Accountability challenges are rapidly shifting, especially with technology. Now, looking ahead, in your view, Kenneth, what is the single most urgent new threat to human rights and civic space that requires a collaborative strategy involving peer, tech expertise, and human rights defense? And in your view, what specific action should the compendium inspire to address it? Should I repeat the question?
It's a very loaded question. I think you may have to break it down.
Okay,
it is, as Aaron said, very pregnant, that question.
What is the single most urgent threat to human rights and civic space that requires collaborative strategy involving peer, tech expertise where you are, and human rights defense work? That is question A. And in your view, for question B, what specific action do you think this compendium can inspire to address that problem?
Doctor, thank you. I will take a moment first think about the answers to this question. I think there are a number of threats, but I would like, I know your question says single most.
Yeah, you can.
Let me highlight maybe two that I feel deserve mention, especially on the side of public interest litigation. I was made aware recently that there are certain countries in the world that are, their livelihood, or really their nationhood, and perhaps even beyond that, their, I don't know if this is a term, landhood, is threatened as a result of rising temperatures, as a result of rising, the ocean basically reclaiming land in that area. One of them is actually our neighbor here, that is Zanzibar. And so the questions, and I know there are a number of island nations that have petitioned international courts of justice and trying to ask that question, that if other countries in the world are causing this issue of climate change, and I know it is debatable in certain places, I think mostly in the political circles, as to whether climate change exists or not. But if you look at it from the context of those countries that are saying, look, 10 years or 20 years ago, we had more landmass than we have now. And at the moment, we are seeing that shrinking and shrinking every year. Should we have some sort of compensation from the countries that are emitting, the countries that are causing these issues? Or should we have any mitigation mechanisms that force countries that emit or countries that are on the way to these emissions to be able to balance the boat and make sure that we are not affected the way that we are being affected? This is for these island nations. And I feel that the more that we focus on the issues that affect us as Ugandans, it's very easy to read the New Vision or Monitor, and all you're seeing are the issues that we're facing in Uganda, but there are other issues that affect mankind. And so I feel when it comes to public interest litigation, it would be interesting if there was a collaboration across different PIL actors in different countries, across the world, to be able to file together and see whether they can be able to have some sort of enforcement or action that would make it so that we pay even closer attention to these issues. And I'm saying even closer attention. There has been a lot of attention. For those of you that know, for example, we have the carbon markets industry across the world that has developed as an answer to that threat of the change in global temperatures. But I feel using this PIL vehicle as we are looking at it now, that can be a good way to be able to look at it then. And then, of course, the thing that we're looking at the most is now artificial intelligence. I am happy with the trajectory of this panel. I think before we're looking into Uganda, now we are sort of being able to branch out and see where we fit in that global picture. But if you're looking at AI and you're seeing that most of these AI applications are being developed in the what we call the West, we see that there is a big risk that we may be disadvantaged as Ugandans, as East Africans, as Africans generally. I traveled to Dubai about a year ago, and I went and visited, I think, the Museum of Tomorrow. I don't know if any of you here have visited it. But it was supposed to be, you know, a good trip where I'm looking at the future of the world, and I'm looking at things like where we're going to be 30, 40, 50 years from now. But I was very scared. Very scared because, one, it looked like the history of mankind was being looked at from the perspective of the West or from the perspective of those with money. And that was interesting because even in terms of the gene banks that they had saying that we are storing these materials for future generations, or looking at the systems that they had in the form of artificial intelligence, things like facial recognition. I remember we stood in front of a facial recognition bot, and there was a colleague of mine, right, that was ahead of me that was fairer skinned than I was. And it said, okay, you okay? You just need to drink some water, I think, or something like that. And then for me, it said that, it said, I don't remember what it said, that I look stressed, I look tired, I look this. So I said, but I look hungry. I said, but I have just eaten. I feel like I am okay. So another lady who was behind me, who also had my same color, also the same thing happened. And then, so I started to notice a trend. Then there was another person that came. This is my own experience. And so coder bias, all these things that we talk about online, looking at how artificial intelligence can be biased or skewed towards those that are creating this system. This is a real thing. And so I think if we are going to have these systems as popular, as ubiquitous as they are, especially in all of these areas that we're looking at, I know for a fact that now in every system of government, in every business environment, we use these systems, even here. But the question is, if we are not intentional about contextualizing that use to be able to reflect that fairness across the board, then we may be and we may continue to be disadvantaged, and that will be such a shame. And so for those, I will end with, for those of you that are lovers of cinema or film, there's a series I love called Fallout. It's a new series that shows maybe what will happen if nuclear war was to erupt in the world. And this is, by the way, a real thing. I don't know whether you know, apparently there are about 38 or so nuclear weapons that are unaccounted for in the world. But we don't talk about these things, you know, the way that we should, because one, they are scary. You know, how do you sleep knowing that any time we may have total darkness, you know, everywhere in the world, especially now with the geopolitics that is happening across the world and the different conflicts they're in. But if these are threats that it is likely that these may change the way of life as we know it, then how are we as public interest litigators, how are we as legislators or policymakers, how are we rising to that occasion and saying, look, is there a section, maybe it could even be a minority, because of course the issues we have may be bigger and may be more urgent than these issues, but is there a section of legislators or a section of government in particular, or PIL, laws, and that's where tech perhaps would be able to come in, because then you collaborate with other lawyers, with other litigants, and then we see, can we look at this problem? Can we look at these problems in a way that represents fairness, and in a way that represents also that inclusion for all of us that may be affected when these things come to happen? So I would think those would be, off the top of my head, the two things that I feel PIL would really help.
Thank you. Thank you very much. And that is a good conversation that you have opened our eyes to, because even in his forward, the ambassador of the Federal Republic of Germany, I can properly pronounce Matthias. The other name might be abused, unintended. So if you read his forward, he tells us how our own Article 50 is very generous, and yet in Germany you would never be able to get what we've been able to get using Article 50 because of the kind of legal setup that is in Germany. So some kind of comparative constitutional analysis would be interesting in that regard. So I will now come to first Aaron, and then His Excellency is also a lawyer. Awesome, awesome, awesome. Thank you. So I'll go to Aaron and then to Dr. Honoria. Yes. Senior Counsel, if you don't mind, I will open the floor without pressure. Yes. Yeah. Let's just finish this and then we shall come to you. I'm just going to have there are 4 short reflections from Aaron, from Dr. Honoria, and from Dr. Hassan regarding that impact. And then I'll ask Dr. Jennifer just to say something about civic education. Is it the role of the Independent Electoral Commission? If it is or it is not, what is the Electoral Commission doing? How can it use this compendium in regard to what it is doing? Then we shall open up the floor for, and Rakafuzi will be the first. Senior Counsel Rakafuzi will be the first one. So Aaron, very quickly, otherwise the plenary wants to take over.
Yeah, yes. I understand. So there are some cases that have been profoundly impactful in reality. For example, the case of Liu San Yun on disclosure. At the time it came, there were judges who were doubting, but now every court, every magistrate knows that the accused is entitled to disclosure. That is true for a represented accused. Unfortunately, the trend which should change is that courts don't respect the rights of full disclosure for unrepresented clients. I don't know whether other litigators have realized that. So they never, if you are going to take over a file, you find that the person is purporting to represent themselves without anything to rely on, what the other side. So it's very interesting. The Obo decision was very profound for media freedom. Even some journalists know it. And that is the profile of the case, because most of these cases are known among lawyers. But when you say a case goes to the public and they know it, they cite it, that is impact. And of course also on peer, like for lawyers, jurisprudence, the board decision on human rights litigation. Can you draft human rights submission without talking about a board decision? No. You have to bring it in the proportionality test, the onus and the burden of proof and so on and so forth. Salvatore Abuki was monumental on issues of torture and repudiation. There was a time it was a culture here to expel people from their communities who had wronged them. I think it is still part of some customs, but it's not illegal. It is illegal and people know it. But also for torture. Ostrako, Ngonda Ntende made a high court decision that was appealed and unsuccessfully, and it affirmed the fact that in the constitutional dispensation post-95, government can be sued, or it is the same. It is not part of, it's not the crown. The constitution is supreme, not the crown. And it was so fundamental and monumental, but I feel people are forgetting it. What they are taking for granted at some point was debatable. You sue government and the guy, the first PO is that they didn't put in a statutory notice. And of course, Kabandiz emphasized that also. So these cases led to even legislative feats like the Human Rights Enforcement Act. A very wonderful law, but of course, whose implementation has been mixed. But the Prevention and Prohibition of Torture Act, these are fruits of this litigation. Yes, so we could go on and I think I should be inclusive. Thank you.
No, that is very good. And Fidelis, we need probably an X space or a radio engagement for us to show this trajectory right up to the people. Yes, Dr. Noria. Thank you, Aaron.
Yes, I think for me, I would just look at the civic impact I'm going to look at it from the context of a class of rights that sort of seem to have been ignored at the time of drafting the constitution, they were dumped into the national objectives. That's the socio-economic and cultural rights. You find anything referring to shelter, food, healthcare, education, and clean water were all put in that national. Of course, the amendment of article to introduce Article 8A is important, but the kind of public interest litigation that has gone around socio-economic rights has greatly impacted those sectors. From listening to the team that litigated maternal health care, you see that what they have achieved, not just in terms of the decision, but in terms of policy changes and the budgetary allocations is critical. If you look at the early litigation around environment by TIN on the tobacco-related second-hand smoke, that has informed a lot of what happened. I remember one time standing at Europec, where the canteen is, and there was this gentleman who was smoking, and I'm trying to tell him that, can you stop doing this? And he tells me where are the signs. Telling him that these are not smoking area. But you see the impact of the tin and the Philip Karugaba pushing this has changed a lot of how we think about second-hand smoke and smoking in public places. It has defined much of what you find now in most public spaces. It led to regulations. If you look at what Greenwatch did, and these were rights which were not really really seen at the time of the Constituent Assembly debates. These were thought for these were state aspirations and all that. If you look at, as I've said, healthcare.
I'm hoping the Fidelis team is taking note of, because this is very important information. On my own, I think I'm going to even do an academic paper. But please conclude and we.
Yeah. So basically, I think that's for. But as Aaron has already pointed out, even in the terms of civil and political rights, there's been great changes that have happened. I think for why probably we need to have this as a more periodic, regular process is that then if you are able to distill those important and impactful decisions and then have this brought to the attention of the public. The fact that it would then be easier for someone to say, oh, so this is what the court has said about this constitutional provision and my rights, and therefore then enables people to appreciate it. One of them, I'm just going to conclude on the most interesting thing, that even human beings have become so innovative because of understanding that their right to, for instance, to assemble doesn't require police authorization or police prohibitive behavior. Now, in spite of the decisions, the police continue to behave that way. So I was going to conclude by pointing out on those two ladies, I don't think there were three, who popped up in parliament dressed in normal outfits and then undressed to demonstrate. That shows that you can actually exercise your right. That means that they were aware that they have that right. They just became innovative on how to really execute the exercise of the right. Thank you.
Thank you very much. Dr. Hassan, very quickly, any known impact as a result of the cases from the African Court for Human and People's Rights and the Commission?
Yeah. First of all, I must admit that the countries Aaron have suggested, like Kenya, like South Africa, and some countries, mostly in West Africa, are the countries which take the pronouncement of the African Commission and African Court to the letter and implement in their countries very seriously. They have also their own local courts, regional court like ECOWAS, but I commend on them. Sudan, unfortunately, you know what happened? The state almost collapsed, but Burkina Faso implemented and compensated the journalists. So, yeah, exactly. Their success and their failures, but it's actually now upon us, all of us, to engage with the Commission, to engage with the court, And the same way you are engaging with your national institutions here, or national court, and then try as a civic activist to insist implementation. That's open as steel, and there's a way to go on that. But I want to also flag, since this is my last remark as we are opening the podium, there are around 5 categories, particularly here is full of legal minds, who are particularly at greater risk than any other groups or human rights defenders in this country. Number 1 is environment, land rights, and resource extractive activists, who sometimes may need specific, protection cases or petitions related to the protection of their rights. Second group is women human rights defenders, or women in particular, particularly those who are in rural and marginal groups. I think interest can be picked up and studied some of their cases and create some sort of a landmark work. The third group is soggy groups, and I think many of you have been shying away from that. But when it comes to equality, inclusion, and diversity, it's something which every one of us benefits, whether you are a member of the group or you are not. So when you see human person is being discriminated, you must stand up for them and say that discrimination, violation, because of some person's perceived identity is outside the law, as the judge have briefly said and is mentioned in the case. And then there's another group who are particularly vulnerable during the elections, suppose, and we call them electoral monitors. And I think groups who work with you, who may not get access to photo education, who may not get access to observation, they may need also active voice to at least tally to the commission, to the obligations in giving them access. There's one more group which we say people who are just against impunity, particularly high-level impunity, and those who are campaigning against corruption. There might be a specific interest by the lawyers to study the peculiarity and the fear they have and pave the way legally the work they are going to do there. So again, I commend totally what you have done, and I think the compendium would go a long way in building some sort of a legal practice in your country. Thank you.
All right. Kenneth, don't feel discriminated against. I'll come back to you for a second chance at some point. Jennifer, just a comment, and then we shall go to Councillor Rakafuzi.
Thank you, Daniel. At least you've not behaved like the way I felt when I was a first year. They said, did you read this case? And then you start panicking and all that. But then I appreciate the questions that you've raised forward. On the issue of civic education, the mandate lies with the Human Rights Commission. Now, for the commission, we are supposed to have voter-oriented education for the voters. So ours is a subset of the civic education. Now, what has the commission done? Under the law, still we are allowed to accredit like-minded people like you who can support the voter education as long as you do it independently. So we've accredited a number of CSOs. Most of them are actually the CSOs. You may also join as friends of the Electoral Commission and participate in the voter education. Then this same group can also partner with Human Rights Commission in the conduct of the wider civic education. So that's what we've done now on Peel. I noticed the cases that affect us on the governance sector. On the Mama Mbabazi case, the impact is that most of them actually formed crucial areas for reforms, and all of them, all the recommendations were adopted and passed into law. Maybe that could be another area of interest, except one on the use of affidavit evidence. That's the only one which hasn't been done. Then I still think there are some practical challenges also which we need to look at as we pursue public interest litigation implementation. And we have one case which we have to look at, and that is it was mentioned here by professor? No, he said he wasn't a professor. The one who said he's not a professor. Yes.
Upcoming professor.
Upcoming one. The issue of diaspora voting. Yes, that came out. We really had practical challenges. At the time it came out, we had already gone through the roadmap, so we could not implement. So we went into a consent judgment for progressive realization. Now it came to a point after the general elections was part of the key areas for reforms. We actually had to have, we didn't think it was just Electoral Commission affairs alone. We had to bring the other sectors on board. And then NIRA came on board because they're the ones who register citizens abroad out there. Now the issue which became most challenging was that would we have a comprehensive registration of all persons in the diaspora? Would it be realized? If we make it, because we said we could do progressively. Now if you are to do it progressively, what will the others think if they are left out? So those are some of the practical challenges we had. However, we still now have the premise that even out there, all those diasporas can still come back and participate in the elections. So those are some of the practical challenges that I see with one of the cases that came out here. But it's a good thing because another case, I think, which is not also cited here, actually helped define what elections should be, what's free and fair elections. So it's a good thing. FLI, you are doing a good job on PIL, and you also I think accredited as voter educators, and I think the synergy is welcome. So elections not just for the EMB alone, it also involves other stakeholders for which we need to or ought to work together to build synergies to achieve the goal of output from, say, PIL. Thank you so much.
Thank you very much, Jennifer. And this is an open invitation for the Electoral Commission to come to the School of Law and teach our students on voter education. As and when you want to, we shall provide the students, and I know they will be good agents of the work that you're doing. Let us hear from Council Rakafuzi, and as he's speaking, I like to complain that amicus curiae does not appear in the compendium. And yet there is even a hotel named after amicus curiae. Isn't that impact on the community? All right, anyway, Senior Counsel.
Just one slight observation. There was a case, I think, in the Constitutional Court of 2004. I don't remember the parties, but it was about whether the movement system was a political party or not. Well, the Constitutional Court concluded that according to its behavior, it had a secretariat, had everything a political party has. It is a political party itself, and that therefore, in the circumstances, Uganda was riding under a single political party, which had been prohibited in the Constitution, and this case led to the opening up of space for other political parties to participate in elections. So it was a successful public interest case. There are not many successful public interest cases because government does not take them seriously, but at least that one they took seriously. They amended the law and allowed the participation of political parties. That is my observation.
Thank you very much, Mr. Rakafuzi. Yes, we have opened up the plenary now. If you have any comments or questions that you'd like to share or reflect on, this would be a good...
as they pass the mic around,
Yes.
the reason that case was successful, because implementation, you need to understand the context, was partly because of international interest, especially development partner interest in pluralism. Yeah, so that case was very monumental and it contributed hugely, and just don't lose the context because it was also very important.
Thank you. Thank you very much. So there is a part that our development partners can continue playing to support the implementation of the fruits from PIL. Yes, there is a gentleman here. If you would give him the microphone. Since Susan, you already have it. Okay, fine. All right.
Thank you very much. I am Henry Biansi.
Oh, okay. All right. Yes, go ahead, Henry.
I want to thank Fidelis for this nice work. However, a quick perusal, I noticed that there is something else we need to interrogate. Aaron and myself have been, in the recent past, trying to handle Peel, but by way of judicial review. And I've noticed we are majorly focusing on human rights enforcement and constitutional petitions. We have challenges as we speak today with the introduction of Rule 3A in the 2019 amendment judicial review rules. You move court, and the first point of law the Attorney General will raise is that you don't have sufficient interest in the matter before court. For instance, I know my brother Kenneth likes private-public partnerships. If I wanted today to challenge the award of maybe funds to the construction of Luwa Hospital, if I'm an aggrieved person and I want to challenge such a process by way of judicial review, in case it does not fit within the confines of a constitutional petition, I'll be constrained. So as litigators or as actors in this space, how do we interrogate Rule 3A of the judicial review rules and put it under scrutiny so that we widen access to court for litigators? Thank you.
Yes, thank you very much. Yes, Susan, you want to say something, and then after we shall go to Councillor Rakafuzi, and then we shall close. Yes, Susan.
Thank you very much, Dr. Ruhweza. My name is Hope Bagota. I work with the Uganda Human Rights Commission, and I'd like to comment on the issue of civic education. This compendium goes a long way in that particular aspect of civic education, because civic education is for us to provide information to the population to be engaged in the democratic process. And as Uganda Human Rights Commission, it's our core mandate. Yes, it's a huge mandate. We cannot go at it alone. We work with as many partners as possible. And this is very welcome, because these public interest litigation cases end up getting into everyday conversation, into comedy, like you had said, into dramas, into poems, on radio spaces, among students, the young, the illiterate. Everybody begins to speak about this, and we can see change come through these avenues. I would also want to add my voice that let's go ahead and simplify it for everybody to understand. And in those little, our attention span as professors and lecturers, you are very alive to the fact that our attention span as a generation is this small. If you don't get to the point very quick, you lose that person's attention. So if you can make them simpler in our different languages and really minimal to be easily digested and have this ball rolling across the entire country. Thank you very much.
Thank you very much. In case you need some people who like to create hashtags, like I've said in Makerere, we have so many students there who will support you in that work. Yes. Yes, Senior Councillor.
I want to say something about what she has said about illiterates. I think it's a derogative word about people. People are not illiterate. They are just unschooled. But many people are very well informed and educated, and they can reflect very deeply on many issues. What Mr. Hassan said, that we should be careful about the way we address people, because it takes away their dignity, and it may push them away from our capacity to influence them on the road to democratization.
Thank you.
Yes.
Thank you very much. Thank you very much. You reminded me of someone who called us the great unwashed. All right. 2 issues have been raised. I think, Kenneth, it's only fair that you're given an opportunity to respond. And then I think the panelists have done a good job, haven't they? Yeah, so let's give Kenneth an opportunity to say something again, because he's the only one who didn't something twice. So just respond to the two, and then we shall call it a day.
Yeah, sure. I just want to add to what my colleague from Chapter 4 mentioned about expanding the compendium. We also have a section or some cases that may not necessarily have gone under either Article 50 or even under the Human Rights Enforcement Act, but that have that effect of actually making it so that sections of the public benefit. So I would say, for example, there is a constitutional petition we filed for the Abavandimwe, the Rwandans who are seeking to have a sense of identity or belonging under our constitution in a country. And the challenge, of course, is that although they were successful in the sense that that matter was then picked up by His Excellency the President, and they were then assured, I think there was an executive order that was issued, making it so that they could easily be able to access, things like getting a passport and things like that. But I feel that maybe there are cases like those that would have benefited from going the actual distance, and you have a decision that would help other people. I've had a discussion with one of my partners, Asmahani Saad, who has actually written a book which is going to launch in about a month, looking at identity. And she's saying that for her history is from Comoros and Somalia and Kasese, but then the fact that her father, her grandfather were born in Uganda and have been in Uganda, because of how she looks and her name, she's still denied an opportunity to be able to have a passport the same way that I would go, but purely based on how she looks. And if you go there and if you can't speak your local language, your local dialect, then they say, maybe you're not part of this country. And so I feel that cases like those, there's an opportunity for them to be able to do more, to be able to enforce rights of a section of Ugandans that may be disadvantaged. And then I'd also like to say, there was a comment from Dr. Kabumba talking about state, I think, what did he say? State interest litigation. We also have business interest litigation. And so there are also cases from the private sector, like Winnie Asege versus Opportunity Bank, that set rights like image rights, that made it so that if you were a sportsman, if you were an artist, if you were a musician, you could be able to you have a right over your likeness, over your image. And so cases like those, I feel, also deserve mention if you're looking at it from the context of public interest. And then maybe lastly, since I may not get an opportunity to be able to say, I would also like to say that overall, and this is in response to what Dr. Kabumba mentioned about the state of the judiciary, in regards to the decisions that are released, and perhaps the seriousness or cogency of these particular decisions. But I'd also like to say that I feel it is a bit dangerous, especially with where we are, to put everyone in the judiciary in the same boat. Because here we are celebrating cases or landmark decisions that have affected or that have led to positive changes in our country. And so I feel it is important, at least not to try and speak about burning down these institutions or really putting all of them in the same boat. But I feel, a clever strategy perhaps would be, why don't we ring fence those judges that are actually making decisions that we like to cite? I'll give you a very good example. We had a landmark decision from the court this year earlier on that made it so that civilians should not be tried in a general court-martial. And we saw how it was difficult for government to be able to enforce that particular decision up to now. I hope Aaron will be able to mention a thing or two about that. But we saw that there was a judge in the High Court that was willing to hear, and I think earlier they were saying that Article 122.6(2)(e) is dead. But that judge evoked that particular article and said, I will not look at any issues perhaps that may stop this man from being able to get bail, and granted Aaron Kiza bail. Now that judge in particular, I'd like to say, is one that we should celebrate. But then of course the other judges who you will look at and no. So I think there has to be that balance for us to be able to now be intentional about celebrating these judgments or decisions that are good, and then criticizing the ones that are not. So I think, Fiona, you should take this seriously about having a compendium of cases that are, yes, that are bogus, because then we can be able to discuss them. No, then we can discuss them, and perhaps then we can appeal to those individuals to be, you know, perhaps they'll be ashamed not to release other decisions, or for other courts not to rely on those particular decisions, but in the same way continue to emphasize that judicial independence that is important for any economy or for any country.
Thank you very much, Kenneth. Yes? Yeah. Yeah. Thank you. Thank you very much, Councillor Kafuzi, and I'd like to thank our panel. For those who are wondering what we've been doing, we've been trying to ensure that we understand the need for these important decisions reaching the community. And why must we reach the community? Because Objective 29 talks about the duties of a citizen, and that the duties of a citizen should be implemented even as the citizen continues to enjoy the citizen's rights and freedoms. So in enjoying your rights and freedoms, you also have a duty. And if you look at Article Objective 29, it talks about many of those, which include promoting constitutionalism, good governance, even responsible parenthood, among other things that I think put in context why it's important for appeal from the courts to come to the community, and when in the community, to charge the citizen to be able to do something about the things that are happening around them. Thank you very much. We will do what the first panel did. We shall also go and take a photo with the Venerable Senior Counsel of Peel. Thank you very much to the panel. I'm sure the conversation will continue. Thank you. After, okay, yes. After our picture, we'll take a group photo. Thank you very much.
Could we first have the picture here, then we could move?
Because it is the panel enjoys special privileges. And then after we'll... if you don't mind.
Fiona? Ladies and gentlemen, not to be outdone, I just want to give a vote of thanks to everybody. Can we just clap for everyone? Thank you for taking out your time. Thank you for making this possible. Thank you to Cass. Thank you, Anna. Thank you all the professors, the dons, the doctors, the civil society organizations represented here, the government institutions. Thank you so much, all of you, because your presence here shows that we have champions for this compendium already. The work is just beginning today. Thank you, Dr. Honoria and Kenneth, for all those way forwards. And we'll be calling on all of you, working groups, the podcasts, as we attempt to even make translations that speak to the ordinary Ugandan. So thank you very much.